Yes.
I say that, please read para 8 as well, sir, please.
Very good.
I say that the petitioner does not possess the necessary qualifications for the purpose of filling up the post of Director of Animal Husbandry and Vet Sciences by way of promotion. That is, neither the petitioner nor the respondent number 5 have held the post.
So both of them are ineligible.
That for the regular appointment.
For regular appointment.
Yes.
Yes.
Therefore, the said post could not be filled up by way of promotion. It is pertinent to note that neither is it the petitioner's case that she otherwise fulfills the eligibility criteria. Please see the next paragraph. I say that under such circumstances and until such time as the post is filled on a regular basis, the charge of the said post had to be given to the existing deputy director in service of respondent number 3. I say that it was therein decided to give charge to respondent number 5 as the said respondent is the only deputy director who possesses the educational qualification which is otherwise prescribed for the post of director.
Both are not eligible. So they possess some part of the eligibility they possess.
Therefore,
That is the only explanation that has been given to your lordship.
State and ask her to take charge now. We all know how it operates, Mr. Ankur.
No, I only have to show your lordship what has been stated before the court.
Lord Council appearing for the state of Goa seeks some time to file a counter affidavit. He is, however, unable to offer a valid explanation as to why the in-charge arrangement made in favor of the petitioner on 31/5/2024 needed to be reversed, whereby what is the Nitin Nayak is respondent number
5.
whereby respondent number 5, Nitin Nayak, respondent number 5 was given in charge status insofar as the post of director of animal husbandry is concerned. In that view of the matter, the impugned. What is the date of the order? 20th June. The order dated 20th June 2024. Which page is it?
62, sir.
Passed by the Under Secretary within brackets personnel to Department of Personnel, Government of Goa is suspended. The earlier order dated 31/5/2024.
57 Manoj. In fact, order dated 4/6/2024 at page 57.
57.
57.
That's 4/6, is it? Not 31.
31 was when both were promoted.
You were given in charge.
I was given in charge on that.
4/6, not 31. Earlier I said 31. Let's make it 4/6. 4/6.
Also, your lordship may not
Suspended.
continue 4/6. Your lordship may only allow her to continue. Because as far as 4/6 is concerned, the state's contention is that one Mr. Volvo was holding the post. He was away from duty, which is why she was given the charge. So then perhaps, my lords, there may be some difficulty. I see what falls from your lordships. Your lordships may allow her to continue.
And the petitioner shall be continued as the in-charge director of animal husbandry and veterinary sciences, Government of Goa, until further orders. List on when do you want to
Immediately on the YouTube. I'll put in my counter.
list on 22nd July.
Great.
Obliged, Manoj. Very grateful.
In this case, there are 4 petitioners. 4th petitioner is the company, 3 are individuals. And these 3 individuals have died. Since this is criminal proceedings, so by way of letter,
Who died?
is petitioner number 1, 2, and 3.
Here, the respondents of petitioners.
Yes.
I see I've noted the High Court. Petitioners 1, 2, and 3.
2, 3, and 4 must.
1, 2, 3 individuals, they have died.
One is
the Karnavati.
No, but through. Because
One is Karnavati.
Karnavati through Pannal. The lordship may kindly see that.
Kanhaiya Lal Pannala.
Kanhaiya.
He passed away.
He passed away.
Then Surajmal.
Surajmal also passed away.
Savarman.
Yeah, he also passed away.
Savarman also.
Yes, my lord. And so far as 4 is concerned, this company was closed in 2009 itself. And this company,
The
because
company was only directed to pay a fine.
yes, my lord. And since this is a case under Prevention of Food Adulteration Act, company is always prosecuted through some nominee. Petitioner number 3 was a nominee.
And this first petitioner is a firm, is it?
Yeah, proprietorship firm.
It's a proprietor.
So Kanhaiya Pannalal was the.
He also did.
Yes, my lord.
So matter awaits. What about the company though, the fine amount?
Company, my lord, since 1/1/2009, it is not in
These
operation.
companies, the 3 and 4, perhaps the issue might survive. But
Three-
the companies.
3 died
3 also,
because
you'll,
under the Prevention of Food Adulteration Act, my lord, under section 17, always for a food business company, a nominee is appointed. So whenever there is a prosecution, he is liable.
only he would be,
Only he would.
no
be-
one will step into his shoes
No,
in case
because-
he is out
No, man. If he is replaced, because if
by
there
the
is,
company itself.
yes, because what happens
So
if
if the person dies, it can't be that the company will go scot-free because the person
Company-
who was representing it died.
problem is, my lord, if your lordship will see section 17. Section 17 says,
We won't have that here. No?
Company has
We
paid
are
fine,
calling from the liability.
has fine been paid.
no, my lord, because this order was challenged. So
We
I
will
have
pay
no
the fine.
instructions. I have no instructions so far as payment.
R4,
Yes, my lord.
the others also. The others
Others,
also fine amount.
no, my lord, because it was challenged and I have no instruction that.
You have any instructions as to whether fine amounts have been paid? You don't know. What does the provision say according to you?
Yes, my lord, 17(2).
What is it?
17 is offences by companies. 17(2) says any company may, by order in writing, authorize any of its directors or managers, such manager being employed mainly in a managerial or supervisory capacity, to exercise all such powers and take all such steps as may be necessary or expedient to prevent the commission by the company of any offence under this act, and may give notice to the local health authority in such form and in such manner as may be prescribed, that it has nominated such director or manager as the person responsible, along with the written consent of such director or manager for being so nominated. So
So
if
once the nominee is.
any
named,
offence is committed,
he would be liable. The nominee is liable.
No, but will it?
Now, when did this man die? The Savarmal?
Seni. I will give the dates. Savarmal Seni died on 30th April 2021.
21.
And again-
So after that, this company must have again named another nominee?
My lord, company surrendered license and closed in
It's closed.
2000. In the letter
2000?
itself, I have mentioned
When?
1/1/2009.
9.
Yes, my lord. In my letter,
Company has been liquidated.
closed its operation and surrendered its excise license. Because being a manufacturer under Prevention of Food Adulteration Act, unless there is a license, they can't function.
But we'll record, otherwise you see,
Where is
company, not functioning, so it may not matter.
What about the other company, Kuber Tobacco?
Uber Tobacco is the company, my lord.
No, your Kuber, I see, both are the same.
Both
Yes,
are
3 and 4 same.
through that fellow.
So separately, a fine is imposed on the company and the nominee is supposed to undergo the.
Yes, my lord.
And also pay a separate fine. Apart from the company, this nominee was also directed to pay fine. 10,000.
Yes, my lord.
10,000. Then what remains? We will close the matter.
In that case, my lord, only with one request to put a quietus to the matter. So far as this payment of 25,000 by the company is concerned, that may kindly be waived.
That may,
Kindly be waived.
the company itself is not there, you're saying,
That's correct.
but you're not telling us whether it's liquidated or not.
No, because since the persons have died and these are.
It has to be wound up though, it's a company.
So for that, I
It will be
don't
recovered in accordance with law.
You just leave it there.
very well,
In the event the company's assets are still there,
very well,
then it's open to them to take steps.
very well.
Mr.
Sanjay Kumar Pathak.
Mr. Sanjay Kumar Pathak, then counsel appearing for the petitioners. What is the letter? Not seen it.
Just now. Last page is the letter.
Just now. Joint counsel for the petitioners. States that this special leave petition may not survive for consideration on merits as the petitioners are no longer in existence. Petitioner number 1 is a sole proprietorship, and its proprietor and Kanayalal Pannalal, its proprietor is stated to have expired. Date is also there?
Yes, my lord.
Expired
21st January
2023. Hazarbai Surajmal Pannalal, petitioner number 2, is stated to have expired on, you have the date
29/4/2021.
on 29/4/2021. While Savarmal Saini, the nominee of Kuber Tobacco Products Private Limited, petitioner number 3, expired on 30/4/2021. He would further state that Kuber Tobacco Products Private Limited, which is shown independently as petitioner number 4, closed down in 2009 and surrendered its license under the
Prevention of Food Adulteration.
under the Prevention of Food Adulteration Act
1954.
1954. In the light of the aforestated development, as petitioners 1, 2, and 3 had to suffer incarceration for the prescribed, not prescribed.
No, they have not undergone.
For the as sentenced by the trial court, which stood confirmed by the High Court.
Trial court acquitted.
Trial court acquitted you. One said sentenced by the High Court, as sentenced by the High Court, and also pay fine, which are now rendered incapable of execution. The matter shall stand closed insofar as they are concerned. Insofar as regards Kuber Tobacco Products Private Limited, petitioner number 4.
Mala, sorry to interject, but so far as if your lordships are going to say that in accordance with law, that means judgment is
such fine on merits. The stage is specially petition is accordingly closed, setting aside the judgment and order dated 13/2/2020 passed by the High Court of Gujarat at Ahmedabad in criminal appeal number 194 of 2008.
Let me be careful.
This
So we are setting a item number 5.
grateful.
The police is posted.
appeal is. Yes.
This is appeal by the state lordship. Notice was issued way back in 2020. The respondents have entered appearance stated recently in the
Counter affidavit is not.
not filed.
Record.
Record also has to be summoned in lordship.
Will grant leave then and call
Please,
for the record.
record to be summoned.
The record will be a requisition, usually translation to be anticipated.
Leave maybe.
The copy will be supplied to document digital form to, if your lordship may
We'll
kindly.
give you a date, 25th September,
Your lordship may also direct them to supply
e-copies.
print copies.
Item number
Please, my lord.
R1.
Number 47.
That notice has been issued in 2022.
Yes.
We will, but after this call 47. Notice was
Issued in 2022 of January, my lord, but respondent has, despite notice, has not entered appearance yet. It's a
complete.
state appeal, my lord,
Postal
against the
track
acquittal from the
report.
High Court.
No, but state, you should be in a position to at least get hold of it.
The service is completed, my lords. We'll,
Available warrant should be issued. He doesn't come in. Despite. One opportunity. Notice of notice. Respondent number 1. K. Raghavan, respondent number 1 has not chosen to enter despite service of notice as long back as on 15/2/2022. K. Raghavan, respondent number 1 has not chosen to enter appearance before this court. Registry is directed to issue a bailable warrant for a sum of ₹10,000 along with surety for a like sum to ensure his presence before this court. The said warrant shall be executed through the jurisdictional police station. You know the details of the police station, details of which shall be furnished by the learned counsel for the petitioner state within 1 week. List on,
it's MAITY police station, my lords.
you furnish
Why
it to
not?
the register.
Definitely.
List on 12th August.
My lord, one suggestion, my lord. In the meanwhile, records may be qualified, my lords. As far as in record, only trial court and high court records are there. In the meanwhile, the portions on the
Normally record is called for only after leave is granted. We can still call for the record. The registry is also directed to requisition the trial court record and full stop.
E-copy.
E-copy to be supplied and translations if necessary.
Item 47.
Research. Yes, Mr. Gill.
8 years ago. Should I wait for Mr. Govardhan
Oh,
because
he's not here.
that's
Is
because
this colleague is here?
He's just on his legs,
Very well, you just make notes.
very
Yes.
my lord, before placing the law relating to my lord execution and authentication of registered instruments, my lord, in trying to answer what fell from your lordships yesterday regarding section 34. My lord, there are 2 or 3 judgments, including a latest one, which was rendered in April 23rd of April 25. It doesn't come in the regular SCC. Therefore, we got the copy in SCC online.
Yeah. Which para?
Lord, if your lordships kindly have a look at paragraph 18, where the issue is posited for consideration.
Yes.
Para 18. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the following question of law falls for our consideration. Whether the High Court was right in taking the view that the suit of the plaintiff for declaration of title based on a valid gift deed should fail, as a plaintiff omitted to pay for the consequential relief of cancellation of the sale deed, or a declaration that the same is not binding on him.
Directly on the point.
Directly on the point. Before we proceed to answer the question of law as formulated above, we must look into sections 31 and 34 of the Act 1963. And those are, my lord, extracted.
Well,
And then, my lord, paragraph 24. This, my lord, with great respect, the judgment of the full bench of the Madras High Court, which has been referred to and approved, my lord, in more than one judgment of the Honorable Court, including the present one. I'll place copies of that. The manner in which, my lord, it has been considered, and then the law has been so succinctly, with respect, so succinctly, my lord, formulated. The full bench of the Madras High Court in Padatti Pillai versus
Where are you
Krishna,
reading? Which part?
my lord, paragraph 20.
20.
The full bench of the Madras High Court in so-and-so versus so-and-so considered the scope of section 39 and 41 of the Procedural Relief Act, which are now sections 31 and 33 of the Act. The principle entrenched in section 39 was explained thus. The principle is that such document, though not necessary to be set aside, may, if left outstanding, be a source of potential mischief. The jurisdiction under section 39 is therefore a protective or a preventive one. It is not confined to a case of fraud, mistake, undue influence, etc. And as it has been stated, it was to prevent a document to remain as a menace and danger to the party against whom, under different circumstances, it might have operated. A party against whom a claim under a document might be made is not bound to wait till the document is used against him. If that is so, he might be in a disadvantageous position. If the impugned document is sought to be used after the evidence attending its execution has disappeared. Section 39 embodies a principle by which he is allowed to anticipate the danger and institute a suit to cancel the document and to deliver it up to him. The principle of the relief is the same as equitimate actions. It was further laid down as under the provisions of section 39 make it clear. The three conditions are requisite for the exercise of the jurisdiction to cancel an instrument. The instrument is void or voidable against the plaintiff. Plaintiff may reasonably apprehend serious injury by the instrument being left outstanding. And three, in the circumstances of the case, the court considers it proper to grant this relief of preventive justice. On the third aspect of the question, the English and American authorities hold that where the document is void on its face, the court would not exercise the jurisdiction while it would, if it were not so apparent. In India, it is a matter entirely for the discretion of the court. The question that has to be considered depends on the first and second conditions set out above. As the principle is one of potential mischief by the document remaining outstanding, it stands to reason that the executor of the document should be either the plaintiff or a person who can, in certain circumstances, bind him. It is only when it could be said that the instrument is voidable by or void against him. The second aspect of the matter emphasizes this principle. So there can be no apprehension if a mere third party assigning a hostile title creates a document. Thus, relief under section 39 would be granted only in respect of an instrument likely to affect the title of the plaintiff and not of an instrument executed by a stranger to the title. Then, my lord, Deccan paper mills, which, my lord, is a recent judgment of 2021 4 SEC 786. That also, my lord, I'll place a copy before your lordships. Judgment rendered by Justice Narima. My lord, also refers to Mupadati Pillai and then approves it. This court held that the proceedings under section 31 of the Act are in person in nature, and therefore any question pertaining to section 31 would be amenable to adjudication by an arbitral tribunal. While stating so, this court explained the ambit and scope of section 31 in detail and authoritatively held that the expression any person occurring in this provision does not include a third party, but is restricted to either a party to the instrument or any person who is bound by a party to the instrument. Placing reliance on Mupadati Pillai, this court observed thus. The court then continued its discussion as follows. Mupadati Pillai, which your lordships, it has been extracted. And except my lord, paragraph the 14 and 15 of Mupadati Pillai, which has not been extracted, my lord, in the earlier paragraph. My lord, would your lordships like to take a lordships to that? Or,
Read it. If it's relevant, I would like to see.
yes, my lord. The paragraph 13 of Mupadati Pillai, your lordships have seen. And then 14. And then 14, 13 and 14, your lordships have seen. But 15, let us take an example of a trespasser purporting to convey the property in his own right, not in the right of the owner. In such a case, a mere cancellation of the document would not remove the fraud occasioned by the assertion of the hostile title. Such a document, even if cancelled, would not remove the assertion of the hostile title. In that case, it would be the title that has got to be judicially adjudicated and declared, and a mere cancellation of the instrument would not achieve the object. 42 of the specific relief act would apply to such a case. The remedy under section 39.
No, para 15, first 3 lines.
Yes, madam. Let us take an example of a trespasser purporting to convey the property in his own right and not in the right of the owner.
Not in the right of the owner.
Yes.
Does it make any difference to your case?
Yes.
Here
Which
he
is
claims to
claiming
be
under the GP.
under the GP of the owner.
Yes. Therefore, the boot is on the other foot. In this case, in that case, my lord, a cancellation of the instrument would not be sufficient. What they say is that he should also seek a declaration of his title to the property. Here, my lord, he seeks a declaration of his title on the strength, my lord, of an instrument which is executed in his favor by the admitted owner of the property. What your lordships are considering is whether is it enough, or should he also seek to get the sale deed, my lord, purported to be executed by the power of attorney holder set aside. Section 42 of this physically fact would apply to such a case. The remedy under section 39 is to remove a cloud upon the title by removing a potential danger, but it does not envisage an adjudication between competing titles. That can only relate to instruments executed or purported to be executed by a party or by any person who can bind it in certain circumstances. It is only in such cases that it can be said there is a cloud on his title and an apprehension that if the instrument is left outstanding, it may be a source of danger. Such cases may arise in the following circumstances. A party executing the document, or a principal in respect of a document executed by his agent, or a minor in respect of a document executed by his guardian de jure or de facto, a reversioner in respect of a document executed by the holder of the anterior limited estate, a real owner in respect of a document executed by the binamida, etc. This right has also been recognized in respect of forged instruments, which could be cancelled by a party on whose behalf it is purported to be executed. In all these cases, there is no question of a document by a stranger to the title. The title is the same. But in the case of a person asserting hostile title, the source or claim of title is different. It cannot be said to be void against a plaintiff, as the term void or voidable implies that, but for the vitiating factor, it would be binding on him. That is, he was a party to the contract. There is one other reason for this conclusion. Section 39 empowers the court, after adjudicating the instrument to be void, to order the instrument to be delivered up and cancelled. If the sale deed is or purported to have been executed by a party, the instrument on cancellation could be directed to be delivered over to the plaintiff. If, on the other hand, such an instrument is executed by a trespasser or a person claiming adversely to the plaintiff, it is not possible to conceive the instrument being delivered over not to the executant but his rival, the plaintiff. A reading of the aforesaid judgment, this we come back to Deccan, of the full bench would make the position in law crystal clear. The expression any person does not include a third party, but is restricted to a party to the instrument, or any person who can bind such party. Importantly, relief under section 39 of the Specific Relief Act would be granted only in respect of an instrument likely to affect the title of the plaintiff, and not of an instrument executed by a stranger to the title. The expression any person in this section has been held by this court to include a person seeking derivative title from a seller. The principle behind the section is to protect a party or a person having a derivative title to a property from such party from a prospective misuse of an instrument against him. A reading of section 31(1) then shows that when a registered instrument is adjudged void or voidable, the court may then order it to be delivered up to the plaintiff and cancelled in exactly the same way as a suit for rescission of a contract under section 29. Thus far, it is clear that the action under 31(1) is strictly an action inter party or by persons who obtain derivative title from the parties and is thus an in personam. The decision in Golam Lalchan, there only also Supreme Court, that is the 2024 SEC Online Supreme Court 2456. I'll place the copies of that also. But there's only one paragraph in the judgment, which might be relevant. And that is extracted here, in paragraph 23. A faint effort was made in the end to contend that the plaintiff respondent Nandulal had not asked for any relief of cancellation of the sale deed, by which the property was purchased by the defendant appellant Golam Lalchan, and therefore is not entitled to any relief in the suit. The argument has been noted only to be rejected for the simple reason that 31 of the Specific Relief Act uses the word may for getting declared the instrument as void, which is not imperative in every case, more particularly when the person is not a party to such an instrument. This observation made in Golam Lalchan must necessarily be understood in the context of a preceding discussion. All that has been stated therein is that as section 31 of the Act uses the word may, it is not a mandate, even as regards the parties to the instrument or the persons claiming through or under them, to seek for the cancellation of an instrument which is otherwise void, and therefore it cannot be contended that a stranger to that instrument must necessarily seek for its cancellation. By no stretch of imagination can this be construed to mean that when there exists an instrument with respect to the same property but executed by some other person, the plaintiff, despite being a danger to that instrument, would fall into the scope of any person in Section 31 of the Act. Having explained the scope of Section 31, we now deem it necessary to examine Section 34 of the Act, which reads thus: discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denied or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration, where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. A trustee of a property is a person interested to deny a title adverse to the title of someone who is not in existence and whom, if in existence, he would be a trustee. Section 34 entitles a person to approach the appropriate court for a declaration if that person is entitled to any legal character or any right as to any property. Legal character and right to property are used distinctively, so that either of them exclusively may be the basis of a suit. The disjunctive or cannot be read as a conjunctive and. The object of the proviso to Section 34 is to obviate the necessity for multiple suits by preventing a person from getting a mere declaration of right in one suit and then subsequently seeking another remedy, without which the declaration granted in the former suit would be rendered odious. However, the answer to the question whether it was incumbent upon the plaintiff to ask for further relief must depend on the facts of each case, and such relief must be appropriate when consequent upon the right or title asserted. Further relief must be a relief flowing directly or necessary from the declaration sought. That is, the relief should not only be capable of being granted, but of being enforced by the court, and such relief should be necessary to make the declaration fruitful. The relief must also be such that it is not automatically granted to the plaintiff by virtue of the declaration already sought for. The words used in proviso to Section 34 are further relief and no other relief, since a further relief must flow necessarily from the relief of declaration. If such further relief is removed and is not connected in any way with the cause of action which is accrued in favor of the plaintiff, then there is no need to claim a further relief, and the proviso to Section 34 will not be a bar. All that the proviso forbids is a suit for pure declaration without necessary relief, where the plaintiff being able to seek such a relief is omitted to do so. The proviso must not be construed in a manner which compels the plaintiff to sue for any and all the relief which could possibly be granted to him. The plaintiff must not be debarred from obtaining a relief that he wants for the reason that he has failed to seek a relief which is not directly flowing from the relief of declaration or the sought for. Where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed under Section 31 of the Act. But if a non-executant seeks annulment of a deed, he has to only seek a declaration that the deed is invalid or honest or illegal, or that it is not binding on him.
No, just pause there.
Yes.
It is still dealing with that deed. One is asking for setting aside of the deed.
Yes.
Another is saying that declaration that deed is not binding on him.
Correct. Therefore, my lord, what your lordships are considering.
What we have here is a declaration that I am the owner.
Yes.
You don't touch upon those documents.
Documents
In the prayer, you don't allude to those documents. So in the body of the plaint, you do.
Yes, yes. There is an assertion, but not in the body of the plaint.
What is the final conclusion?
This final conclusion.
In relation to the question posed there.
My lord, para 30, read with para 35 and 36.
30.
Are you missing out?
Not obligated.
Para 30, 34, 35, and 36. My lord, I took your lordships to paragraph 18, which says this is a question.
You've already.
My lord, I follow what falls from your lord.
First three lines.
Yes, yes, you have to
Facets of the coin.
yes, but the only thing is, my lord, that's with 34 and not 31.
Something must be there. Because suppose somebody alienates, some prominent governmental institution or a building. There's no obligation for of India to go around seeking declaration.
That's right.
An example here.
That's right. But here it's a right in person. Therefore, that's what the lordships are considering whether. Therefore, it was mandated on his part to have sought for a declaration or for setting aside, my lord, the power of attorney, and not the power of attorney, but the sale deed as such. Power of attorney, my lord, he need not get it set aside. But he can always get it, he could have sought for getting the sale deed set aside. This is what falls from your lordships. My lord, your lordships may just permit me to complete this, and then your lordships may consider, my lord, whether this is. As observed aforesaid, a plaintiff who is not a party to a decree or a document is not obligated to sue for its cancellation. This is because such an instrument would neither be likely to affect the title of the plaintiff nor be binding on him. We have to our advantage two very old erudite judgments in the Madras High Court and one of the Privy Council on the subjects. This, my lord, this paragraph 30 by itself, my lord, seems to give an indication that the court has come to the conclusion that plaintiff was not a party to a decree or a document who was not obligated to sue for its cancellation. This is because such an instrument would neither be likely to affect the title of the plaintiff nor be binding on him. We have to our advantage two very old erudite judgments in the Madras High Court and one of the Privy Council on it.
Para 34 perhaps.
30.
34, the last
Can I
sentence.
just read 31 also?
31 also makes it clear, Unni's case.
Yes. If a person not having the yes, sorry.
Earlier judgments are
Yes.
able to. But
If
this
a-
judgment again in para 34, the last
Yes.
sentence frames the question which arises.
That's right.
here.
That's right. Well, can you just go through 31 also, just
31.
for the sake of completion? At least for the felicity with the manner in which we. If a person not having authority to execute a deed or having such authority under circumstances which did not exist, executes a deed, it is not necessary for persons who are not bound by it. By to sue to set aside it for it cannot be used against them. They may treat it as non-existent and sue for their right as if it did not exist. The same principle has been distinctly laid down by the Privy Council in Bijoy. 1907 SEC Online Privy Council 1, where the jural basis underlying this transaction was pointed out. In that case, a reversional suit for a declaration the release granted by the widow of the last bail owner was not binding on him and also for cast possession. It was objected that the omission to set aside the lease by a suit instituted in the timeline prescribed by Article 91 of the Limitation Act was fatal to the suit. The following observations, which are equally applicable to the case at hand, are opposite. A Hindu widow is not a tenant for life, but is owner of it is in those days which we consider as archaic now in the present circumstances. But the law, my lord, has been considered in this way. A Hindu widow is not a tenant for life, but is owner of her husband's property subject to certain restrictions on alienation and subject to its devolving upon her husband's heirs upon her death. But she may alienate it subject to certain conditions being complied with. Her alienation is not therefore absolutely void, but it is prima facie voidable to the election of the reversionary head. He may think fit to affirm it, or he may at his pleasure treat it as a nullity without the intervention of any court, and he shows his election to do the latter by commencing an action to recover possession of the property. There is in fact nothing for the court either to set aside or cancel as a condition precedent to the right to the action of the reversionary head. It is true that the appellants prayed by the plaintiff for a declaration that the ijara was inoperative as against them as leading up to their prayer for delivery to them of caste possession, but it was not necessary for them to do so, and they might have merely claimed possession, leaving it to the defendants to plead. And if they could prove the circumstances which they relied on for showing the ijara or any derivative dealings with the property were not in fact voidable, but were binding on the reversionary heads. In fact, it is logically impossible for a person who is not a party to a document or to a decree to ask for its cancellation. This is clearly explained by Justice Wadsworth in a decision rendered in Vellayat Konar versus Ramaswamy Konar, reported in 1939 SEC Online Madras 149. Thus, when the plaintiff seeks to establish the title in himself and cannot establish the title with removing an insuperable obstruction, such as a decree to which he has been a party or a deed to which he has been a party, then quite clearly he must get the decree or deed cancelled or declared void in toto. And a suit is in substance a suit for the cancellation of the decree or deed, even though it may be framed as a suit for declaration. But when he is seeking to establish the title and finds himself threatened by a decree or a transaction between third parties, he is not in a position to get the decree or deed cancelled in toto. That is the thing which can only be done by parties to the decree or deed or their representatives. His proper remedy, therefore, in order to clear the way with the view to establish his title, is to get a declaration that the decree or deed is invalid so far as he himself is concerned, and he must therefore sue for such a declaration and not for the cancellation of the decree or deed. Therefore, filing a suit for cancellation of the sale deed and seeking a declaration that a particular document is inoperative as against plaintiff are two distinct and separate suits. The plaintiff in the present case, not being the executant of the sale deed executed in favor of R1, was therefore not obligated to sue for its cancellation for Section 31. Question that remains with respect to the plaintiff ought to have sought for a declaration that the sale deed dated 5597 was inoperative, insofar as he is concerned or is not binding on him. One should not lose sight of the fact that the suit for declaration of title to be decided by a court takes within its fold consideration of several factors as to how the plaintiff is entitled for declaration of title. In such cases, the plea of the defendants about the validity, enforceability, and binding nature of any document defeating the title of the plaintiff are also to be considered. In such cases, the court naturally views the evidence on both sides, leaving apart the frame of the suit. But this is precisely what happened in this present case. Therefore, the High Court, having concurred with the courts below on the legality and validity of the gift deed, should not have dismissed the suit only on the ground that the plaintiff failed to pray for cancellation of the sale deed. The High Court should have kept the settled position of law in mind that the declaration of title is as good as a relief of cancellation of the sale deed, or at least a declaration that the sale deed is not binding on the plaintiff being void and thus non-est. Furthermore, then two other judgments which had
Certified directly on.
yes.
Mr. Giri, if you had not cited this, this is a very relevant judgment.
See,
It is a good thing that we put the question to you and you took time to at least do this research. Otherwise, if you don't cite relevant case law, then tomorrow you will blame the Supreme Court for giving in contradictory decisions. Unless you people do your homework and present to us the case law as on that date, the legal position as settled by this court up to that date, we will not be able to know what has been decided by another bench just the day before. And then who is blamed? Not you, we. We will be blamed for giving contradictory decisions. Very good. What is the other judgment?
generally, my lord, the persons who had argued the matter but lost it would be the first ones to blame the court also. Unfortunately, I don't do it, but that's not, I'm just putting it as a general measure. But we should have brought it to your lordship's notice yesterday itself. We need not have waited for your lordships to put that question. And then your lordships were gracious to give me time till today to at least place a law before your lordships. I'm deeply obliged for that. We should have, but especially when the appellate court had looked at this issue and then come to the conclusion that the suit may not have been made.
That was raised before the High Court. The High Court, in fact, takes note of the fact that you do not seek cancellation of those documents. So that was very much an issue. It's not that it was raised by us for the first time.
No, your lordships are right. Your lordships are right.
Very well. What
I'm
is the other
sorry, I
judge?
should have. My lord, can I just place before your lordships, hand over copies of the other judgments which are referred to here?
Which have been referred to?
Yes.
Very,
My lord, I need not have again take your lordship's time for that.
you can just conclude your
Yes.
arguments on
Yes.
and we'll hear Mr. Global.
No, that we have. And ultimately, my lord, the conclusion is at paragraph 46. Where my lord see.
The answer to the question is framed is perhaps in the earlier paragraphs.
Yes.
It's not set out thereafter.
Correct. My lord, I'll place copies. I'll hand over copies of the Mukherjee and other judgments to my learning friend also.
You said the relevant paragraphs have been extracted here.
Yes.
You
Then
don't,
that's
need,
and
you
we
don't
can't.
need to waste paper.
No.
We'll look at the judgments.
Very
You don't need to waste paper.
Sorry.
There must also be some ruling.
Sorry.
Following up on this principle.
Yes.
Not after.
Yes.
That the judgment should be sent to the registrar also to make an endorsement somewhere, because
That has to be done.
how will he know otherwise, you see? This is correct.
The
because you
provision
don't have
also
to-
requires it.
You don't have to seek every declaration, but once the inter partes something is found,
Lordships are right.
otherwise people seeking encumbrance certificate from the
That's
registrar.
Held in your favor, ought to have done that
That's right.
in terms of section 32, perhaps.
Not, maybe not in the context of 31 and 34, but as a matter of general principle there.
Principle there.
Yes. That when
31 2.
there is a title declared in relation to a title deed which was executed later in point of time. That's what happened in the case of the plaintiff in the present case.
So the inter partes is binding. He is a party to the
Yes.
and parties who are seeking encumbrance certificate there.
Lordships are right.
So this can also be forwarded to the registrar's office.
Yes, my lord. Taking a cue from, my lord, the proviso to section
Principles analogous to that provision.
principles analogous to this.
Which means
Because that's the effect, my lord, what your lordship said.
31 subsection
Yes,
2
yes.
specifically requires.
Yes.
There is a declaration.
Once there is a decree, it has to be communicated by the court.
That's good. What my lord is indicating is that even if
There is not setting aside the
there is no decree setting aside it, but it amounts to that because the court is declaring
It has that effect. Once it has that effect, it needs to.
and then it should necessarily, as a matter of law, go to the. Your lordships are right. That is something which your lordships can think of, my lord, as a matter of, if your lordships are inclined to deal with this aspect, my lord. My lord, there are my lord, on the question of, my lord, just one more aspect down at page 388, your lordships were yesterday, not lordships had put it to me that the trial court had not entered a specific finding that the power of attorney was not executed, my lord, by D3.
Yes.
Your lordships are right. He did not, the trial
Give
court.
a specific finding.
Yes. But at page 380 to 381, that is the last portion of paragraph 33. Before in para 34 onwards, the court considered the issue from the context of admissibility and execution of the sale deeds exhibit B 127 to 129. There is considerable discussion, my lord, in paragraph 33, starting at page 379. And then in the course of considering the defense raised, my lord, by the defendants in the last 5 lines of paragraph 33 at page 381, before paragraph 34 began.
Yes.
And in the course of considering, my lord, 2 documents which are relied on by the defendants B 122 and 123, details of which are, my lord, referred to in the earlier portion of the same paragraph, the same page. In para 3 of the written statement, it was mentioned that the second defendant issued notice to the corporation along with some documents in respect of the house bearing of the Sunsu. It is not at all mentioned that the documents filed by the second defendant include the alleged notarized affidavit of the deceased third defendant. So, basing on exhibits B 122 and 123, it is futile to contend that the burden of proof of the execution of the general power of attorney stands discharged. And then, my lord, the court goes into the question as to how B from 125 was marked, deferring the question of admissibility of the document with reference to the provisions of the Stamp Act and the Registration Act, pursuant to an earlier direction issued by the High Court, my lord, in a revision at the instance of the plaintiff, and the trial court said that I need not go into this question and consider an issue. Then, my lord, at the end of it, there is a detailed discussion, and at paragraph page 388 is a finding which your lordships have seen. At paragraph 42, my lord, 39 at page 388 before paragraph 40 begins, and at 40.
If the answer to the specific issue with regard to the execution of the document
stands,
if that's answered,
yeah,
and it's answered in your favor, saying that the GPA has not been executed by Ranveer Singh,
then they need not gone into the other questions.
The other question doesn't even survive. Whereas the trial court seems to have given more importance to the second.
Yes, your lordships are right.
And doesn't give a clear
It would have been
first issue.
Your lordships are right. Last 3 lines of paragraph 39, my lord, deals with B23, that receipt, my lord. It has not been placed on record. I have copies here.
39.
Yes. Paragraph 39 at page 388.
Yes.
All the above would lead to the irresistible conclusion that the final receipt under B23 is not true and genuine. I therefore find that the final receipt under B23 is not true and genuine. Since it is found that the final receipt is not true and genuine, it follows that the payment of sale consideration as resided in the 3 sale deeds is not true. And it also proves that the sale deeds are not supported by consideration.
No.
Yes.
Where were they registered, these 3 sale deeds? Which register?
Same register. Same register.
Which one? Which one?
Where your sale date was registered.
Yes.
It would be obviously the same register. Jurisdictional register would be the same.
Sorry?
But they don't look into the issue as to whether there's an earlier document. They are only bothered about the registration fee and the stamp duty.
My lord, see, question of authentication, my lord, which has been gone into in great detail, my lord, by the trial court and which has been reversed, my lord, by the appellate court. My lord, may still be open to your lordships, my lord, because there are 3 judgments, my lord, which deals with 2 judgments directly dealing with authentication. And there is a 3rd judgment which deals with, my lord, the manner in which a power of attorney can present a document for registration. My lord, see, why I say 2022 8 SCC 210, my lord, is because it also refers to an earlier judgment called Rajini Tandon, which has been relied on, my lord, by the appellate court. Trial court, my lord, goes into the issue by looking at the provisions of the Act. And there are 3 or 4 judgments, my lord, of the Andhra Pradesh High Court. Appellate court, my lord, considers it from the angle of Rajini Tandon also. Rajini Tandon was referred to, my lord, by the Honorable Court in asset reconstruction, apart from other judgments. And asset reconstruction, my lord, goes into it in great detail in considering the provisions of the Act and also the provisions of the rules, my lord, which are applicable there. The Tamil Nadu Registration Act, which, my lord, almost are in pari materia, my lord, with the rules that were applicable in the present case, my lord, prevailing in Andhra Pradesh.
Which
Lord,
paragraph?
it's a fairly elaborate judgment, and therefore, my lord, I will not trouble your lordship with the entire
Paragraph?
thing.
Which are the relevant paragraphs?
Yes. Paragraph, only not 17, my lord. My lord, just a brief conspicuous of the facts, my lord, at page 3.10, at page 219.
No.
Page 219, paragraph 3.10. Eventually, the appellant filed a writ petition and writ petition number 33462 of 2014, seeking a declaration that the act of the sub-registrar and registering the sale deed executed by SP Velayudan, my lord, who was a respondent in this case, in favor of his son Amar was null and void. The said writ petition was allowed by a learned judge on the ground that there was utter failure on the part of the registering authority to follow the mandate of law as prescribed in section 32 to 35 of the Registration Act, and the registrar failed to verify the deed of power of attorney dated 23/8/2006 before allowing registration of the sale deed executed on the basis of the said power. However, 2 intra-court appeals filed by the fathers and duo were allowed by the division bench primarily on the ground that the appellant ought to have taken recourse to a civil suit, that the appellant is guilty of violating the order passed by this court in the proceedings arising under the order of subdivisional magistrate under section 145 directing the parties to approach the civil court. Agreed by this order to the division bench, the appellant has come up with the above appeals. Assigning the impugned order to the division bench of the High Court, it is contended by the learned senior counsel for the appellants that the High Court has failed completely to appreciate the Registration Act enjoins upon the registering authority to verify the person executing the documents ought to be registered, that in cases where the statutory authorities fail to perform the duties enjoined upon them under specific provisions of the statute, the jurisdiction of the High Court under Article 226 of the Constitution does not stand ousted, that what was challenged before the High Court in the petition under 226 was not the act of individuals but the acts of omission and commission on the part of the registering authority, and hence a petition cannot be said to be not maintainable. That by an oversimplified process of reasoning, the division bench of the High Court threw the appellant out of the court and also added insult to injury by committing upon the conduct of the appellant and imposing cost. Thereafter, there is a narrative of what had taken place, my lord, and then ultimately, if your lordships kindly come to paragraph 17, paragraph 14 onwards, my lord, 12 onwards, my lord, the provisions of the Registration Act are extracted. But please permit me, my lord, because the process of the ratiocination, my lord, the reasoning starts, my lord, from paragraph 14 onwards. I'll skip, my lord, the sections.
Yes.
Section 32 of the Act mandates that every document to be registered under the Act, irrespective of whether such a registration is compulsory or optional, shall be presented by any other persons mentioned there in Section 32 of the Act reads as follows. And C is, my lord, what we had, what your lordship had seen yesterday, where it says, my lord, when it's by agent of such a person, representative or assigned, duly authorized by power of attorney, executed and authenticated in the manner hereinafter mentioned. Both these words may not come for serious consideration in the judgment. The word such person appearing in clauses B and C of section 32 correlate to the words executing, person executing or claiming under the same, appearing in clause A of section 32. In other words, clause A covers both the executant as well as the claimant of the document. Therefore, clauses B and C cover several persons who may represent the executant or the claimant. Since the controversy in several decisions of this court has revolved around clause C of section 32, with which what your lordships are also concerned with, it would be useful for the purpose of easy appreciation to break clause C into its several components as follows. 1, by the agent of the person executing the document. 2, by the agent of the person claiming under the document. 3, by the agent of the representative of the person claiming executing the document. 4, by the agent of the representative of the person claiming under the document. 5, by the agent of the assigned of the person executing the document. 6, by the agent of the assigned claiming under the document. It must be noted that the word agent appearing in clause C of section 32 goes not only with the word such a person, but also with the words representative and assigned. This is for the reason that the representative and assigned are independently covered by and hence if these words do not go with the word agent, then their appearance in clause C would be redundant. Then, my lords, para 17. By virtue of the second part of clause C of section 32, it is necessary that if a document is for registration is presented by any of the aforementioned 6 categories of persons, he should have been duly authorized by a power of attorney, executed and authenticated in the manner mentioned in the other provisions of the Act. In other words, in cases where a document is presented for registration by the agent of the executed or of the claimant or the representative assignee of the executed or claimant, the same cannot be accepted for registration unless the agent is duly authorized by a power of attorney, executed and authenticated in the manner provided in the Act. This, therefore, my lord, squarely applies to the sale deeds in question. Section 33 contains prescription regarding the types of POA, which alone shall be recognized for the purpose of section 32. My lord, the section is extracted in its entirety. And then, my lord, at paragraph 19, a careful look at section 32 and 33 will show that while speaking about power of attorney, these provisions do not use the word registration. While section 32C uses the word executed and authenticated, section 33(1) uses the words recognized and authenticated. Therefore, it is clear that the word authenticated is not to be understood to be the same as registered. The reason why we say so is that section 33(1) speaks only about authentication and not registration. And clauses A, B, C of section 33(1) provides a list of persons competent to authenticate a POA. Persons who are empowered by clauses A, B, and C of subsection 1 of section 33 to authenticate a power of attorney are as follows. The registrar or the sub-registrar within whose district or sub-district the principal resides, if such principal resides at the time of execution of the power of attorney, any magistrate, if the principal resides in any part of India where this act is not in force. 19.3, not public or any court, judge, magistrate, Indian council, vice principal, if the principal does not reside in India. It may be seen from the list of persons indicated above that not all of them are registrars and sub-registrars appointed in terms of section 6 of the Registration Act. Under the Act, the power of registration is conferred only upon the registrars and sub-registrar. But clauses B and C of section 33(1) speaks about persons other than registrar and sub-registrar. That is why section 32C as well as section 33 use only the expression authenticated and not the word registrar. But unfortunately, several courts have mixed up these two words, resulting in applying the test in terms of section 17 and 18 for determining the validity of POA. In fact, the distinction between authentication and registration is spelled out very clearly in the Tamil Nadu registration rules. It may be noted here that section 69(1) of the Registration Act empowers the Inspector General of Registration to exercise general superintendence of over all the registration offices in the territories under the state government and to make rules consistent with the Act in respect of matters provided in clauses 8J. Then, these rules, by virtue of subsection 2 of section 69, are required to be submitted to the state government for approval and to be published in the official gazette after such approval. The rules so made in terms of section 69 in the state of Tamil Nadu provide clarity on the distinction between authentication and registration. 48 and 49 of the Tamil Nadu Registration Act, registration rules. My lord, lordships may quickly, my lord, have a look at the rules. And then, my lords, after that, para 23 refers to Rule 52. And what your lordships will find from these rules, and these rules will not seem to be in pari materia with the rules, Rule 49 and 53 of the Andhra Pradesh rules, my lord, which your lordship said, which is applicable in the present case. And then at para 25, having seen the distinction between authentication and registration of a POA, the obligation imposed by the Act and the rules upon the registering officer while authenticating and or registering a POA, the necessity for the registering officer to maintain a track of revocation of deeds of POA, and the different requirements of Rule 46 relating to a document presented by a general POA and a document presented under special power of attorney. Let us now turn to the other provisions. Section 34 of the Act contains provisions regarding the inquiry to be undertaken by the registering officer before registration. 34 in its application to the state of Tamil Nadu. Then, my lord, those provisions are extracted.
Is there a civil Andhra amendment?
Sorry.
I don't think it was.
I checked. Is there an Andhra amendment, my lord? I
For
could-
34, 34.
Not the amendment. The Act is what they lordship says. Lord, I didn't find a reference, my lord, in the either the judgments or my lord in the paper book, but to confirm it, my lord, I'll check it.
There is something similar to this.
Yes,
In the Bear Act, as far as I can recall,
your lordships have the, okay.
no. From my past experience in Bear Act,
Very well.
there is something similar to this.
I'll check it.
You remember the famous 22A, but not
22A, of course, is.
On that
22A,
case,
of course, the most notorious provision.
that was struck down. Pending here, my lord, in appeal. Leave ground.
we have all dipped into it.
Lord.
We have all dipped into it.
Yes. We may note paragraph 28.
Agent.
That section 32C, 34(1) and 34(3)C use the expressions agent, representative, and assigned. Though in common parlance, we understand the power of attorney agent of a person to be a representative to the principal. The words agent and representative are used in 32C and 34(3)C to mean different persons. The word representative is defined in section 210 of the Registration Act to include the guardian of a minor and the committee or the legal curator of a lunatic or idiot. The words agent and assigned are not defined in the Act. Therefore, we may justifiably borrow the definition of the expression agent, which defines an agent to mean a person employed through any act for the another and to represent another in dealings with third person. Keeping the above definitions in mind, if we go back to section 32C, it could be seen that whenever the agent is the executant, the claimant, representative, or assigned presents a document for registration, he should have been authorized by POA, and such POA should have been executed and authenticated in the manner provided in clauses A, B, or C of subsection 1 of section 33. The requirement of registration depends upon the state amendments. Now, my lords,
Yeah.
paragraph 40, though confined to the facts of the case. Therefore, if the registering officer had verified the details contained in the registered deed of power of attorney, dated so and so to see if the power agent had the power to do what he did, he would have refused the registration of the document. Rule 46 of the Tamil Nadu registration rules ordains what the registering officer is obliged to do when a document is presented for registration of the special power of attorney, when a document is presented for registration of general power of attorney. It was failure on the part of the registering officer to do what is required to do that convince the learned single judge to invoke the jurisdiction. But the division bench overturned the decision of the learned judge on the ground that the writ court ought to have relegated the parties to the civil court. It is for that reason, my lord, that this is referred to. And then, my lords, there is a reference, my lord, in paragraph 47 to Rajini Tandon, because Rajini Tandon, my lord, is referred to by the appellate court. And, my lord, on the face of it, it may seem to be taking a slightly different view. Just come to paragraph 47, my lord, your lordship's name. Right. I think I think so. But just before your lordship go to para 47, maybe I have missed it. My lord, paragraph 30. My friend is right. But I should have brought it to your lordship. Para 30. What is covered by section 32C, read with section 33(1) is something different from what is covered by section 34(3). That's not inquiry in the state of registration. While section 32C, read with section 33(1) speaks about the entitlement of the person to present a document for registration. Section 34(3) speaks about the inquiry to be conducted and the satisfaction to be arrived at by the registering officer. Section 34(3)C imposes an obligation to the registering officer to satisfy himself about the right of a person appearing as a representative, assign or agent. This prescription has to be read with Rule 46 of the Tamil Nadu rules. 46 of the Tamil Nadu rules. We already read that. We have read that. I'm sorry.
Pointed out.
Already read it. Somebody else is Para 47. Both sides relate upon the decision of this court in Rajani Tandon. The question that arose in Rajani Tandon was as to whether the POA required authentication by the registering authority when a sale deed executed by the power agent himself is presented for registration by the power agent. This question was couched in a different language by this court in para 19 of the report in Rajani Tandon as follows. In view of the aforesaid situation, the issue that falls for our consideration is whether a person who executes a document under the terms of the power of attorney is, insofar as the registration office is concerned, the actual executant of the document and is entitled under section 32A to present it for registration and to get it registered. After analyzing section 32 and 33 of the Registration Act, this court came to the conclusion that whenever agent is authorized to execute a document and present the same for registration, and he accordingly executes a document in terms of the power of attorney, he becomes the actual executant insofar as the registering authority is concerned, and that therefore he becomes entitled under section 33A to present it for registration. This court further held that the authentication in terms of section 33(1)A is required only in cases where 32C is invoked. Para 33 of the report in Rajani Tandon is reproduced for easy appreciation as follows. Where a deed is executed by an agent for a principal and the same agent appears, signs, appears and presents a deed or admits execution before the registering officer, that is not a case of presentation under section 32C of the Act. As mentioned earlier, the provisions of section 33 will come into play only in cases where presentation is in terms of section 32C of the Act. In other words, only in cases where the person signing the document cannot present the document before the registering officer and gives the power of attorney to another person to present the document, that the provisions of section 33 get attracted. It is only in such a case that the said power of attorney has to be necessarily executed and authenticated in the manner provided under section 33(1)A of the Act. But we are not concerned in this case with the question whether the power of attorney is laid upon by the power agent, SP Velayudham, the sale deed executed by him required authentication, and whether the registering authority committed a blunder in accepting the sale deed presented by him for registration without verifying the authentication of the power of attorney or not. We are concerned in this case with the most fundamental question whether the registering authority could have turned a blind eye to the fact that the deed of power of attorney on the basis of which the sale deed was executed, as well as presented for registration by Velayudham, contained an express prohibition for the power agent to create an encumbrance on the property. The decision in Tota Ganga Lakshmi was in a way approved by 3-member bench in Pratyabal Anand on the basis of the rules in the state of Andhra Pradesh, showing thereby that statutory rules also play a crucial role. Rajani Tandon is not an authority for holding that the registering authority has no duty even to verify the presence or absence of a power of sale in the deed of power of attorney, especially in the light of the rules. My Lord, there is a reference to Amarnath, which dealt with the question, my Lord, where who is entitled, my Lord, to present a
Two judges.
Rajani Tandon's two judges.
That be because if the authentication is not there, in what capacity is he executing? I mean, he's only a stranger then.
It's stranger then.
The judgment, he doesn't execute it in his own name. He executes it on behalf of someone. He doesn't become the executant in that sense.
That's what 32C, my lord, specifically says.
See, for him to step into the shoes of the principal, he should have a valid authentication.
Correct.
If he has a valid authentication, he can step in.
Yes.
And you can also look at it in a different way. If you say that a person who is to present the document for registration on the strength of a POA requires the authentication of that POA, would you not need it for the execution of that very document itself? That is a much more serious thing than just presenting a document. And you say this POA requires authentication, that POA doesn't need authentication. That doesn't sound logical at all.
Rajini Tandon, my lord,
It's not been considered in other decisions. What is the
Rajini Tandon is considered in another judgment called Amarnath, which is also two judges bench judgment. My lord, I'll take your lordships to Amarnath,
still holding the field?
holding the field, my lord. But Rajini Tandon should have been looked into with little more care, my lord. This, unfortunately, I mean, 2022-11 SEC 4. Rajini Tandon is 2009-14 SEC 782.
So 2009 though.
Yes. We'll hand over copies, my lord, if you like. And Amarnath is 2022-11 SEC 460. It relies on, it refers to Rajini Tandon. That also I'll hand over. But Lord Amarnath, I also had an occasion.
Where is Rajini Tandon?
Rajini Tandon, Lord Jester. Amarnath. Amarnath. Para 33, my lord, refers to Rajini Tandon. Amarnath, para 33 referred to the first.
Who wrote it?
He's
Had an occasion to assist with the book. But please come to Rajini Tandon, because ultimately that is what has been relied on, my lord, by the appellate court counsel to find that the authentication of the power of attorney was really not necessary. Because in para 40, the appellate court judgment, my lord, the court finds it is undisputed that the power of attorney is not authenticated. Nevertheless, says that it is not necessary because it is a power of attorney holder who presented the document for registration. And therefore, it is not necessary. He is not executed, but he is the, or my lord, that he executes a document as a power of attorney holder, and he is a person who presents it for registration. Executed and presenter are the same, and therefore, my lord, question of authentication is not necessary. This in sum and substance is what the appellate court says. This, my lord, seems to be on a reading of Rajini Tandon. Lordships may consider, my lord, what Rajini Tandon actually dealt with.
How does Amarnath deal with Rajini Tandon?
My lord, Amarnath refers to Rajini Tandon in paragraph 33.
We followed it. And held that once the power attorney holder steps into the shoes of the executant, so that itself would mean that 33 will not apply, 32 will apply.
How does he acquire the status of power of attorney holder?
Well, what Amarnath says basically is, in paragraph 40, what it says is that once the power of attorney holder executes the document himself on the strength, armed with that power of attorney, he executes the document as an executor. So therefore, my lord, 32A will apply and not 33. 33 will apply in a case where an executant, say, is living in Delhi and one of the property is in Chennai. So my lord, he appoints a power attorney holder. For that authentication under 33 will apply. This is what your lordship says. So 32 and 33 my lord, will be alike. If your lordship will be Amarnath, my lord.
Let's see the
So
section.
let me, I'll take a lordship to Rajini Tandon and then I'll take a lordship to Amarnath. Lord, it is appropriate that your lordships have a look at the section first. Lordships have seen it. Nevertheless, part 6 deals with presenting documents for registration. Persons to present documents for registration, except in the cases mentioned in sections 31, 88 and 89. Well, 31 deals with registration or acceptance for deposit in private residence. For the sake of completion, my lord, 88.
So you read 32, there may be a distinction.
Yes.
Let's read 32.
Except in the cases mentioned in sections 31, 88 and 89, every document to be registered under this Act, whether such registration be compulsory or optional, shall be presented at the proper registration office. Lord, I'll A, by some person executing or claiming under the same, or in the case of a copy of a decree or order claiming under the decree or order, or by the representative or assign of such a person, or by the agent of such a person, representative or assign, and then comes the words, and this is what asset reconstruction also referred to, duly authorized by power of attorney, executed and authenticated in the manner hereinafter mentioned. Well, executed and authenticated in the manner hereinafter mentioned, therefore relates to a power of attorney. Authentication therefore relates to the power of attorney. Execution also relates to that. And by the agent of such a person, representative or assigned, will have to relate to the documents which are presented for registration by the agent. Then now, if your lordship straight away come to 32.
No, now March is 32 deals with presentation of documents.
Yes.
Now, who has executed these documents? A document can be executed by the real owner and presented for registration.
Yes.
For example, if I am the owner and my brother is the power of attorney holder,
Yes.
I can sign it at whenever,
Yes.
and he can present it for registration.
Yes.
The other is where the power of attorney holder itself executes the document.
Yes.
So, what does 32 deal with?
32 deals not with 32. A and C will have to deal with different circumstances. Otherwise, it becomes ocean.
By some person executing
Yes.
or claiming under the same.
Where Rajini Tandon and to some extent Amarnath also will go on, is what they say is that there is a power of attorney. He is an agent. The power of attorney holder is entitled to execute the document which the sale is in question. In which case, he is the person who executes the document, and he would therefore be covered by 32A and not by 32C.
But if you see 33,
Yes,
which deals with what power of attorneys are recognized.
that's right. Therefore, they have to be read together. Rajini Tandon, subject to correction, does not deal with 33. Rajini Tandon, I'll take it anyways. Judgment is being considered by you. Just see where 33 is. Let's see. Your lordships are at 32C, and what your lordships are considering a case where, and this is what Rajini Tandon says. Lord, I am a power of attorney holder of my friend. He executes a power of attorney in my favor. and registers it and then authentication done properly. Lord, I am selling a property which belongs to Mr. Rao. Lord, when I do it, the document will have to be executed. There are two things, my Lord, which your Lordships always look at. The power of attorney is only a medium by which, my Lord, the conveyance, the document is not only executed but also presented for registration. But the property belongs to Mr. Rao. He is not, either he is not in India or whatever it is, my Lord, there is a disability. And therefore, my Lord, but when I execute the when the power of attorney also, when the document is executed, it actually says, vendor, Mr. Rao, represented by power of attorney, Mr. Giri. Therefore, my Lord, can we take it that the person, my Lord, who the power of attorney holder who signs it is therefore the executant of the document, and therefore 32C doesn't apply, and therefore 33 doesn't apply. That will be taking it to a level, my Lord, with utmost respect, fraught with serious consequences. Rajini Tandon, except in the case of 32C, and this is what Amarnath also says, 33 will not apply. Specifically holds 33 will not apply to 32A and 32B, and why is because the power of attorney holder, of course, my Lord, Rajini Tandon did not deal with the case of that the issue of regarding authentication or lack of authentication in the case of a power of attorney, as has happened in this case, though there is a reference to that. But I'll take an option to the judge. But Amarnath dealt with the case.
Rajini Tandon and Amarnath.
Yes.
Was the execution of power of attorney disputed by the executant? That will make a fundamental distinction.
Unfortunately, my Lord, in Rajini Tandon, the respondent was not appeared.
No, in the pleadings, you will know the court below. Was there a dispute on the power of attorney? Or was it only on the form of presentation?
Paragraph 19.
Here you see the owner disputes the execution of the power of attorney.
Yes, yes. Para 12, my Lord, is this. Whether the finding of the court as regards the validity of the sale deed exhibit 1 executed and presented to agent Indra Kumar Halani on behalf of the principal on the strength of a power of attorney is sustainable in law when admittedly exhibit 10 was not registered nor an authenticated document in the manner prescribed in section 33. And then at paragraph 19, the court says, in view of the aforesaid situation, the issue that falls for our consideration is whether a person who executes a document under the terms of the power of attorney is, insofar as the registration office is concerned, the actual executant of the document that is entitled under section 32A to present it for registration and get it registered.
Yes. Yes, Mr.
Lord, paragraph, as if your lordships had come to paragraph 22 and 23 of Rajini Tandon.
Rajini Tandon. See, there was no dispute between Nandalal Tantia
Yes.
and Indra Kumar Halani, the attorney. The dispute was between Nandalal Tantia and one Avarani Ghosh Dastidar. Avarani Ghosh Dastidar was setting up a case that Nandalal Tantia did not have valid title to sue for eviction.
Lotships are there. Lotships are referring to paragraph 5 and 6.
In that contest, the argument was
And then paragraph 10. The trial court recorded a finding. 9. Respondent 2 also urged that one Indra Kumar Halani executed the said seal deed on behalf of Nandalal Tantia as his constituted attorney in favor of the appellant and presented the same for registration. It was therefore argued that registration of the sale deed was hit by the provisions of section 33(1)A of the Act, as the power of attorney in favor of Indra Kumar Halani was not executed before and authenticated by the registrar or sub-registrar within whose district or sub-district Nandalal Tantia reside. The trial court recorded the finding that the power of attorney under which the sale conveyance deed was executed was not registered, and the same ought to have been registered as Mr. Indra Kumar Halani executed the said sale deed on behalf of Nandalal Tantia as his constituted attorney and presented the same for registration. Hence, it was held to be in violation of the provisions of 32 and 33 of the Act. Consequently, it was also held that the title of the said premises had not passed in favor of the appellant. Trial court accordingly dismissed the suit as the appellant plaintiff did not acquire any right, title, and interest by virtue of. Your Lordship, the dispute. Yes.
Say there was no dispute.
Yes. But in the question of law, which is formulated in paragraph 12, whether the finding of the court as regards the validity of the sale deed being exhibit 1 executed and presented by an agent on behalf of the principal on the strength of the power of attorney is sustainable in law when admittedly exhibit 10 was not registered nor an authenticated document in the manner prescribed in section 33 of the Registration Act. Then, my lord, if your lordship cuts the change to paragraph 19, in view of the aforesaid situation, the issue that falls for a consideration of whether a person who executes a document under the terms of the power of attorney is, insofar as the registration office is concerned, the actual executant of the document and is entitled under section 32A to present it for registration and get it registered. Then, my lord, in paragraph 22 and 23, clause A of section 32 specifies that the document can
Para 26 also it is the same reiteration.
Yes.
Once he executes the document as a power of attorney holder, so far as the registration office is concerned,
Yes.
he becomes the executor.
Yes.
Therefore
33.
comes under 32A.
Lordships are right. Para 33, ultimate conclusion. Where a deed is executed by an agent for a principal and the same agent signs, appears and presents a deed or admits execution before the registering officer, that is sorry.
From this, under section 34(3),
Yes.
when the registering officer is supposed to inquire, the things that he is supposed to look into. If you look at 34(3),
Yes, my lord. The registering officer shall thereupon inquire whether or not such document was executed by the person by whom it purports to have been executed. Satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document. And in the case of the named person appearing as a representative, assignee, or agent, satisfy himself for the right of such person.
Such person would be assigned.
That would therefore, may not trace it to section 32C. And if 32C applies, then 33 applies. Or 33 applies to the entirety of section 32.
They would have to be read together.
They have to be read together. My Lord, Rajini Tandon goes on the principle, your lordships are right. The question as to whether the power of attorney was properly executed and authenticated did not arise for consideration in that, because that was not a matter in dispute. Your lordships are right. In fact, my Lord,
No, perhaps because the other person raised it, that this GPA has not been authenticated, though there was no dispute between the principal and
that's
the
right,
agent.
that's right.
The other side raised the issue
That's
that this has not been authenticated, therefore no title passes.
That's right, that's right.
So in
And
that
then-
context, it fell in issue.
Yes. And therefore, my Lord, but the question which actually came up for consideration, which was decided, was whether the person who executed the document, whether it's the original vendor or the power of attorney holder. But the question as to whether the power of attorney was a valid piece of valid instrument did not fall to
That did
consideration.
not arise at all.
And therefore, Rajini Tandon and therefore Anandan also proceeds on this premise that
Hear what Mr. Govardhan has. to
yes,
say
my Lord,
on this
50
issue. On this issue, because we are a little troubled by this Rajni Tandon.
Maybe.
Only on this issue, Mr. Govardhan. With regard to a person executing a document in the status of an agent, whether he becomes the executant of the document to come under 32A.
I thought
Only on that issue first. Because if we are inclined to disagree with Rajni Tandon, then it would be better we send it to a larger bench.
Right. Would you also have a look at Amarnath case first? I want to show that because that takes care of the content also. The lordship will be in a better position to know.
Which paragraph?
Yes, the lordship will come straight away to para 31.
Yeah.
This is Viswanathan. Yes. The argument of the plaintiff would appear that it is imperative having regard to 32-33 of the Act, original power of attorney should be produced. In view of this, he considered it necessary to advert to section 32 and 33 of the Act, which read as follows. 32 we will also see now, except in the cases mentioned in section 31, 88 and 89. Every document to be registered under this Act, whether such registration be compulsory or optional, shall be presented as the proper registration of A by some person executing or claiming under the same, sees that. Second, or in the case of a copy of a decree or order claiming under the decree or order, or by the representative or assignee of such a person, or C, by an agent of such a person, representative or assigned duly authorized by power of attorney, executed and authenticated in a manner hereinafter provided mentioned. Then my lordship will see section 33. Your lordship will see, for the purpose of 32, the following power of attorney shall alone be recognized, namely.
That is for the whole of 32, not only for 32C.
Correct. For the purpose of section 32, whole. If the principal at the time of executing the power of attorney resides in any part of India, he lives in Delhi, the property is in Chennai, in which case for the time being enforced, a power of attorney executed before and authenticated by the registrar or sub-registrar within whose district or sub-district the principal resides.
Yes.
Then B, if the principal at the time of enforcement resides in any part of India in which this Act is not in force, a power of attorney executed before and authenticated by any magistrate. C, if the principal at the time of enforcement does not reside in India, a power of attorney executed before and authenticated by a notary public or any court, judge, magistrate, Indian council or vice council or representative of the central government. As your lordship said on yesterday that it has to be apostilled in a foreign country. Now, your lordship would skip this and now we would come to the next page, para 33.
33.
Yes.
Yes.
The argument of the plaintiff that for a proper and legal presentation of a document, the first defendant was obliged to produce the original power of attorney does not appear to be sound. In fact, the matter itself is not res integra. This court in Rajini Tandon held inter alia as follows. In view of the aforesaid situation,
One other aspect, just interrupting you.
yes,
there.
yes, no, of course.
The document, if suppose it is executed by virtue of a GPA,
What should we do?
the very same GPA would also, as in this case, authorize that person to present it for registration. In this case also. So once both are combined in the same GPA, even if the person executes the document, the very same GPA authorizes him to present it for registration, then obviously it would need authentication.
No, man. If your lordship will have a look at document in our case,
Look at this.
yes, no, for a second, lordship will
Here also, this GPA.
Lordship will just see page 507 of article. For a minute, on fact. On fact.
I'm looking at the GPA. That's why I'm saying
Yes.
to sign all documents of transfer, such as sale deed, and then the next clause is a couple of clauses later to present and sign all documents of transfer before the register authority.
By executing the same in
So once both are combined together, this is the GPA which is authorizing him to present the document for registration.
Correct. And now lordship
The question of his becoming the executant no longer survives there.
No, lordship will see page 518. The same. It's important. So the first document would be in that asset reconstruction company which my learned friend was relying upon, there the power of attorney did not authorize him to encumber the property.
Sorry?
In the asset reconstruction case, if your lordship will have a look at para 49 of that, your lordship will see.
Para 49 of
asset reconstruction. But what the lordships have said, that Rajni Tandon is not an authority exactly for the proposition, because in that case it was incumbent on the registrar to see that the power of attorney authorized him to sell or encumber the property or not. In asset reconstruction company, your lordship have held that the power of attorney did not authorize him. Have a look at
sell it.
Yes,
Sell it.
yes.
That may be so, but you have to answer this question.
So Rajni Tandon
In your case,
yes.
once the GPA authorized this person, Rajendra, to sell as well as present the document for registration.
Correct. So what
This
is that?
GPA is what is the basis for his
Correct.
presenting the
So
document.
therefore,
it needs authentication.
no, man. Therefore page 510.
It becomes the principle
No,
there.
no, 32. Because otherwise 33, 32 and the A and C and the 33 will become same.
If he is executing the document in his own name, then this GPA need not have said that he is authorized to present the document for
No,
registration.
he has to say, if your lordship will just have a look at 5 and 0. Well, before
5
that,
and 0.
well, would your lordship just let me complete the paragraph 49 so that I'm done with that asset reconstruction?
Asset reconstruction.
Yes.
No, that we have already noted. That
No,
the GPA in that case did not authorize the sale at all.
So this is what your lordship just
On
said.
that ground, the bench said that Rajni Tandon is not relevant.
Correct.
to our-
So placidum D and E of paragraph 49 at page 233. Just 3 lines of it.
Yeah.
Rajni Tandon is not a placidum D and E. Para 49 comes to of asset reconstruction.
Asset reconstruction.
This is 2022 8 SCC. Para 49, page 233.
Yes.
Rajni Tandon is not an authority for holding that the registering authority has no duty even to verify the presence or absence of a power of a sale in the deed of POA, especially in the like. So now this is how asset reconstruction has no application. Now if you lottery will see 510. Otherwise, my lord, what will happen is that in every case, well, I can give that example. If I am living in Delhi and the property is in Chennai, I authorize
If your argument is to be accepted, then this clause in the GPA is rendered osseous.
No, no.
Then what is the purpose of authorizing this person
No, that is
to present the document?
yes, because what happens is that if the property is in Chennai and I am in Delhi, I authorize A to I cannot go to Chennai. So I authorize A. So A will go to the registration office.
That is authentication done though. Your irrevocable GPA specifically authorizes Rajendra to present the document.
Correct. Now you also have a look at page 510, the CLD. It's a registered CLD. It says, it is not in my name. Ranveer Singh, the defendant, the owner, and his wife.
So, Mr. Govardhan,
are represented by the
how
GPA holder.
do you get the power to execute?
But
Come to 32A.
yes. (32A).
By some person executing.
Or claiming under the same.
Claiming would be the beneficiary.
Beneficiary. You are now executing the document
I am executing the document.
in your capacity as a power of attorney.
Correct. Correct.
Now, a power of attorney, there is a Power of Attorney Act of 1880.
Yes,
1880.
82.
It says whatever a donor can do, power of attorney can
Can
do.
do.
Now, 33 says, for the purpose of 32, the following powers of attorney alone shall be recognized. If the principal at the time of executing the power of attorney resides in any part of India, for the time being imposed, power of attorney executed before and authenticated by the registrar or sub-registrar, in whose district or sub-district the principal resides.
Correct.
So if the executant,
But this will not apply in this case because this is 33A is in authentication of Rule 49 will apply in a case where the executant cannot physically go to that place for registration and he appoints power of attorney holder A to go and do that. Authentication is for that purpose. When the power of attorney holder himself becomes the executant, as in this case, as executant became, then 33 authentication will not apply. This is what the Lordship have said in Amarnath. Just if you read those three paragraphs. Both will be the same. If your Lordship will see what your Lordship have. Of Amarnath, before I go back to 33, 35.
How do you explain the terms of your own GPA then? If you were authorized to execute the document
Yes,
and present it yourself,
yes.
then you didn't need the authorization to present it.
No.
Why was it necessary for your principal to say that I authorize you to present the document?
Otherwise, 32A will not apply. But if suppose the vendor would have said,
Then once you present it by virtue of this
of the
GPA,
GPA,
then you are not under 32A. You are
I am-
obviously under 32C.
no, I am under 32A, madam. If your Lordship just have a look at,
On the face of it, it's contradictory.
no. Would your Lordship just see para 35? I want to show what your Lordship have said and then I'll come back. I'll
Para
answer.
35 of?
Para 35 of this Amarnath. Now, this is how this court has understood. I am not saying something new from my own. I only followed the law.
35.
Yes. Page 478, para 35.
This is following
Rajini,
Rajneesh.
What the Lordship says that in the
We have grave doubts whether this Rajneesh logic would be.
in the
valid.
fact of this case, let's see what Justice Joseph speaking for the bench. In the facts of this case, the second defendant was armed with the
This is
power.
on, there's no principle laid out. They just mentioned on facts that this was not necessary. Obviously, going by what Rajneesh Tandon had said. But Rajneesh Tandon also must have had similar terms in the
Well,
GPA
I will show
with regard to the
well,
power of attorney holder being authorized to present the document for registry.
if your Lordship will come to para 40, and then I'll go back to 33.
Para 40 of?
Of Amarnath.
Yes.
Page 480. For reasons which we have indicated, and I'll read those paragraphs little later, have indicated 32C read with 33 and 34(2)C are interrelated and they would have no application in regard to the document presented for registration by a power of attorney holder who is also the executant of the document. In other words, there is really no need for the production of the original power of attorney when the document is presented for registration by the person standing in the shoes of the second defendant. In this case, as he would be covered.
This also doesn't take note of 34. 34A.
As we had
It
executed
is
the
not
document,
Thus, the registrar has the duty to verify whether the person who is there before him has the power to execute that document. He obviously has to look at the original power of attorney.
Yes, but it is armed with
So one provision can't be looked at in isolation without taking into account the context of the other
I
provision.
see that, but your office have looked into 32C, looked into 33.
I think it is better that we refer it because we are not able to agree with Rajni Tandon.
But otherwise,
The other judgment also seems to have had doubts about it, but unfortunately left it hanging. But I think it needs to be addressed at some point of time. It's not proper.
But Manoj, then what will happen is that
Let us also tell you it would be equally easy for us to skirt the issue, but I think it's better that the issue stands settled.
But Manoj,
Rajni Tandon has been holding the field for long enough, and
2009.
it might create more difficulties without further clarity on it.
C would become the same. 32, 33 will become the same.
We are only sending it to 3.
I know, Manoj.
I'll send it to a
For
logical.
clarity, you may,
It's better. You may succeed also,
But
but
the three
I think
judges say-
clarity needs
No, I
to be
see
there.
that. Your lordships are not agreeing with this proposition. It's a lordship prerogative.
We'll pronounce the order.
Very
Very well.
Perhaps a detailed order would be.
Very well, very well.
Send it.
It's great. Lord, should we based on the copies of the other judgments?
Not necessarily.
Not, I don't think. I can see that.
Only on this issue.
Yes, Lord.
Yes, one. We're not going to-
Your lordships are not even going on facts. No, I
Yes.
see that.
Yes.
The moment your lordships had only answered this, I realized that
This
your
issue.
lordships are in
Heard you
fact.
fully.
We're not going to go on to the facts. of it.
No, I know that. Your lordships were not
Only on the legal position with regard to this judgment.
Lord, grateful to you.
lordship.
Item 1 is that is also so should we take to
Call.
2 o'clock?
No, call it. Person is there. The party is also here.
Yes, my lords. They suffered a fracture.
Oh,
The respondent party, made him sit in the back.
Oh,
Standing here.
very well. Can you come forward or you wish to? You can, you're in a wheelchair, is it?
No, there is a walker, my lord.
Why don't you use that? You don't have
Yes,
to.
yes. Should I help him?
Please help him. There's no need for him to hop and skip. Yes.
Lord, this is a transfer petition from Delhi Dwarka Court to Hamirpur district in Uttar Pradesh. Lords, there are already some cases pending in Hamirpur. The wife petitioner is also has also a child who is 5 years of age studying in Hamirpur. So we are only requesting there is one divorce case only which is in Dwarka, which may kindly be transferred to Hamirpur district in Uttar Pradesh.
Yes, Mr. Gaurav.
Right, actually, I'm
Speak into the microphone, please.
right. I'm sorry, I'm late.
Oh, that's all right.
So, my
But
name is
one aspect we would like to put to you, the Section 9 petition that she filed is at Hamirpur. Now, ordinarily, a restitution of conjugal rights and a divorce petition must be heard together because they focus on the same issues. There is a possibility of contradictory findings if two different courts hear them. You have not asked for transfer of a Section 9 petition.
No.
So that is continuing at Hamirpur. What is the stage of the Section 9?
Because summons have been issued.
Summons have been issued. And what is the stage of the divorce case?
Because in that case also summons have been issued as soon as summons were issued.
So it is in your interest also that both cases be heard together.
But my lord, I want to say that will be not be beneficial for my daughter because it's for only the extortion case.
No, we will not go into those kind of allegations. We are only dealing with the transfer petition. Whatever issues you have on merits with your wife, whatever issues you have raised in your divorce case, whatever she has said in her various cases which are pending at Hamirpur, we are not going into the merits of the matter. Our only concern is a Section 9 and a Section 13 must be heard together. You have not asked for the transfer of the Section 9. She has asked for transfer of your Section 13 to be heard at Hamirpur. That being the situation, and as you said, we tend to be a little more sympathetic towards women. So we will send it to Hamirpur. You can appear through video conferencing as and when it is permissible. Only when your physical presence is required, the family court will call for you.
But my
Come
lord,
and be present.
video conference is not available.
Video conferencing is not there in Hamirpur.
Yes.
So, my lord, I'll check, my lord, that may not be the issue, my lord, but the problem is that he's appearing, he's even otherwise appearing
He's
regularly.
appearing in the other cases,
Yes,
but as a matter of fact, video conferencing online,
For
not
Hamirpur, my
there.
lord, I'll have to take some instructions of video.
no, because he must have gone there and he would know perhaps.
So, my lord, I'll
You've
take,
gone to the court there and you find that there's no video conference.
I'll take instructions,
my
my
lord.
lord, but otherwise also he's appearing in all the cases there.
1498A, 1 DVC, 125,
Mainly,
and the section 9.
So, but my lord, my case is totally different, because my wife is my wife mother is only filing this case as a extortion of money. My wife sent me message that if she want to take a revert, then she wants to revert from my parents. And they are alleging that my mother and my 75 years old father.
Do you want to
torturing her?
Do you want to attempt mediation?
Yeah,
Settlement
my
or
lord,
mediation?
I am ready for each and everything. I am ready.
What about your client?
My lord?
we want to stay back, because we are fully willing for mediation.
Then we'll refer you to the mediation center.
My lord, I am ready for the mediation. I am ready for
But be with an open mind.
Yes,
Whatever issues you may have with your in-laws also, leave them out.
Yes, sir.
You talk, no parents there.
Yes, my lord.
Let her come alone.
Yes, my lord.
You may be there,
Yes,
but not her parents.
Yes.
According to him, the parents are more at
I understand, my lord. So,
fault.
I understand that, my lord. Then we'll try that the parents, instead both the parties only speak with you.
The counsel, he doesn't have anything against you. You also was helping him with the
I will.
walker. I'm sure he won't object to your
So,
presence.
Malay, she alleged me that I have another wife, I have another child,
Your mother-in-law or your wife?
my wife, because
Right.
he has imaginary. His brother told me that she had a schizophrenia bimari, and she imagined and she many times suicide in. She takes suicide in her.
Are you willing to take her back or no?
Yes, my lord, I am ready to take her, but I have requested that she should accept that she has filed the wrong allegation against me and against my family.
Once you settle the matter, all these cases will go. You don't need to pin her down to a confession that she has made wrong allegations against you. Leave all this negativity aside and try to settle it. These cases will automatically go if you settle the matter.
So it should be settled through
the mediation. Go with an open mind. Try to settle it amicably.
Sir, for my daughter, I am fully open mind and I can settle anyway.
Mediation. But he seems to want legal
You need
aid.
legal assistance. From what you have now experienced in the last 10 minutes, you'll be better off a lawyer.
Mediator.
Mediation.
See how it goes with the mediator. Because if he is not represented by counsel, you also don't go.
But my lord, we will assist, my lord. Even in that case, my lord,
Very
I
good.
have gone through the
Very good.
affidavit. I'll assist, my lord, with that.
My lord, I also want to
I have
add
no difficulty.
that all the allegations.
Do you also want the assistance of an advocate?
Can provide you an advocate.
Even in the mediation, you can have the assistance of an advocate who can guide you on legal aspects. Usual the Supreme Court Legal Services Committee shall provide the assistance of
My lord, I want to add some point.
legal counsel to assist the respondent even during the mediation process on legal aspects.
Will you assist?
Mr. Divyesh Pratap Singh, and don't Mr. Divyesh Pratap Singh and counsel is requested to assist the respondent during the mediation process, as he may not be aware of the legal aspects that may be involved. After that, if it doesn't work out, then we will see
My lord, I want to add two
parties. You appear before the
My
mediator.
lord, I want to add 2 points.
We will not hear you. You go before the mediator now and try to settle.
Yeah, my lord, I am open.
Then why do you want to address it? Address
My
it
lord,
from merits.
my child's future is,
Think about the child's future.
actually seek.
Unfortunately, we find that couples lose no time in
Yes, my lord. Yes.
having a child.
Max, we have
1 year flat,
both
child arrives,
their ego.
and then the differences also multiply.
In this case,
At least they don't wait till that situation where to
My lord,
resolve
my
that
child
situation.
tried
the
to kill my
differences
daughter
will
by
arise.
pressing her neck.
First and foremost, have a child. Then let's decide whether we'll get along together or not.
My lord, my
That
wife,
seems to be the approach.
my wife tried to kill my daughter when she was in
Don't
10
make
10
these
days old.
allegations.
She never.
If this is the frame of mind with which you go, then there's no point in sending you for mediation.
I was just want to live peacefully.
Then why are you making these allegations?
Sir, it's a fact, na.
Whatever it is, leave it now.
Prima facie unbelievable.
Sir,
Sir, today,
Last
taking
last
care for
February.
past 3 years alone, sir. He has not shelled a penny, sir.
Sir,
He's taking care alone.
Sir, I have each penny because sir, whenever I meet the daughter, I give the 10,000 rupees. I have sent her with her 10,000 rupees each month. I have each and proof, sir. I have each and every document, sir.
Anyway.
When will you appear? July?
Ma'am, may I only request, my lords, may I kindly, or the first date, my lords, may I request for the VC for the first date. After that, we'll appear.
On July 15th.
Year-old daughter.
6
Only for
10,000 every month or
Month.
every time you see her once in a blue moon?
Every time when we meet,
That is once in a blue moon.
I don't understand.
Once in a year?
No, sir. Sir, I have done.
You see her every month?
Sir, every month we have sent 2,000 rupees for the RD, and every time when we meet, or
She's 6 years old. She needs to go to
yes, sir, so
school.
I have give the cash.
How will 2,000 rupees be sufficient?
Sir, I have also give the 10,000 rupees,
When?
and every month, and whenever I meet with daughter. Sir, on these they have mentioned that
15th
on 9th
July
I have
at 2 p.m. 2 p.m. first time online. To video conference.
Number 7.
Yes, please.
7.
When the matter was first listed, Mala, so we should notice only confined to the state, my lord, that whether the state has intentions to file appeal against the order.
Now they have filed.
They have filed it.
We have already filed appeal, my lord. That appeal is also tagged. That is 7.1, my lord. Let the
7.
notice be issued in all both the matters, my lord.
This relates to my lord, the section 319, where the trial court has given the detailed finding. Why the trial against the other two accused is important. Because if my lords will see the reasoning are well explanatory, my lords, why, and my lords have held in a n number of judgments, my lords, that
When this notice has been issued, is it not?
only to the
Only to the state, is it?
No, only to me, my lord, to ensure whether I am filing SLP or not. My lord, we have
So now
already
notice
filed.
will have to go to our
Everybody in both the matters, my lord.
in the other matter.
Yes, my lord.
In item 7, issue notice to respondents 2 to 5. Returnable on
And 7.1 also, my lord.
7.1 notice will have to go only to
Only
the accused are there.
Yes, my lord. And he is for the
And
informant.
they
for
issue,
the informant.
you're not a party there.
No.
He is informant.
7.1 also issue notice.
My lord,
Returnable on
one more prayer, my lord. Last time when the notice was issued, registered insisted
29
that
July.
I'm sorry, but when last time my lords have issued notice, the registry insisted that we should file process for others also. We filed process for others,
Yes.
but they refused to take the notice. And the
Notice was sent.
notice was sent. and
Why? The order specifically says only to
It's there,
respondent
but
number 1.
we clarified later on to the registry. But the envelope which was returned, it says they are not residing there. So, my lords, I am requesting you, my lords, may consider the notices through trial court, my lord. Because they
They're not
might
residing there, is it?
they are residing there, but the envelope came back with a remark that they are not residing there.
Let us see now, because now we are issuing notice. Earlier notice was not even issued, so we
Well,
can't take notice.
I'm great.
You take out notice thereafter.
My lord, grateful.
Number 8.
Item 8. Item 8.
He's online.
Online.
My lords, I appear for the state.
State counsel is appearing online.
My lord, I appear for respondent number 3.
3.
Yes, my lord.
3 is a private party.
Yes, my lord.
Yes. You are appearing for the petitioner.
Yes, my lord. My lords, the main counsel is having some throat infection.
No, notice has already been ordered in this matter, is it not?
Yes, my lord.
So the other respondents, you are appearing only for 3.
Yes,
My lords, I
Listen
am
to the
appearing
other
for
respondent.
state. State is respondent number 1.
You are appearing for respondent number 1.
State
The
1.
state.
Yes, my lords.
But the other respondents?
I appear for respondent number.
Respondent number?
Respondent number 4 is the only one who is unrepresented.
4 is unrepresented.
Yes.
Is served though?
My lords, service is complete.
Complete, sir. Service is complete.
Only respondent number 4. Rishipal Singh.
Yes.
There is no representation for Rishipal Singh, respondent number 4. It doesn't say when this notice was served though, it says complete.
My lords, it says the office report says on 12th of January
12th
2023
of
it was
January,
issued.
notice was issued.
Yes, my lords.
Notice served on blank.
Yes, my lords.
I don't know whether you can trust me. Notice afresh to respondent number 4. Returnable on 29 July. Registry shall mention the date of actual service in the office report.
My lords, he can be served through the trial court.
Trial court, the matter is not pending.
My lords, but they must have the detail, or he can be served through the SHO, my lords.
Unless- We'll leave it at that for the time being. Let us see.
Item number 9.
May I please also item number 9. My lord, this is an unfortunate case. One brother has killed another brother, and the eyewitness is mother.
Mother,
My lord, this court has
he
issued
threatens to hit you with a stone and you go and get a knife and stab him.
quantum of sentence.
Chopper, not even a knife. What is that? Chopper is
Chopper is, my lord, say one type of axe.
axe.
This is some types of axe which is found in kitchens.
And you go into the house, get it, and then you attack him with
My
that.
lord, this is the thing. The whole story. My lord.
Where is the sudden and grave,
My lord,
grave and sudden provocation?
This is totally sudden provocation, which I'm just trying to establish this.
And who was drunk? He was drunk or you were drunk?
No, my lord, he was.
He was drunk. So you don't even have that excuse.
No. My lord, we are giving clear picture to the court.
Being drunk, he only threatened to throw a stone at you.
The whole
And being sober, you go and get a chopper and chop him up.
My lord, hear the story, please. This my lord mother, who is a widow mother, my lord, was having her sister made an arrangement to survive her livelihood. And for that purpose, she made a plan to give her rubber plant to her hold this elder brother, elder son. Elder son, this lady had come to take the expenses, per month expenses, rupees was decided. And before these expenses, she used to come regularly in a month. My lord, on the particular day, she had come to take 1,000 rupees as decided by her own sister. That elder son said that today I don't have, I will pay shortly. On this person
other brother has come and say that you are wasted money, you're wasting money in liquor, and you have a drinking habit. And on that basis, my lord, they have a hot altercation between them. And mother intervened into the matter. And finally, when they were just going out, this person from this X, whatever 6X or chopper, my lord, just assault from backside, my lord. 2 injuries were there only. One is better.
It's even worse. You hit him on the back.
Yeah. My lord, even then, this is something which is no intention, no premeditation, nothing, my lord, in this case. And even, my lord,
Where was the attack? Inside the house or outside?
this is
outside.
just when they were stepping down from the house. Well, my lord, just see this thing.
I remember reading that you went into the house to get the chopper.
No, my lord.
You were outside and then you went in, got the chopper and then attacked.
They were going. So these all
was attacked from back.
These are also big houses, my lord. Small houses just to come down then.
Anyhow, the bench earlier seems to have had some sympathy, so we'll just keep it.
My lord, this is
today we are writing now.
The thing, this mother is
of
now
your
85
school of
years old.
heaven.
But I'm submitting, my lord. This mother is 85 years old.
One brother you killed, you are sitting in prison, so you use your mother now as
My lord, this
lever.
lady, even my lord, in personal basis,
Bad enough you put her in this position. Now you want to use her as.
My lord, this court has issued notice of quantum of sentence.
Only-
He has already undergone 12 years.
12 years.
Yes.
2 more years you'll be out after that.
No, my lord, this is life in prison.
Provided killing a brother, I don't know.
But see the scene.
Premature release,
My lord, this is
killing a brother might be an exception.
Lady is put in lady, my lord, more than 85 years.
You can't
And
use your mother now as
no
an
one
excuse
is
to-
no one is to look after her.
That's
the
not
family, my
5
lord.
children are
No one is to
5 children are there.
5 children.
Oh, 5 children.
No, my lord, there are 2 daughters, my lord. One son, there's no history of the other son.
Two
Two
daughters.
sons were killed. One son is killed by another.
He must be scared of you, so he must be running for his life.
My lord, my lord, that she is now 85 years.
Well, don't leave the mother out of it. You already visited enough punishment on her. Every time she sees your face, she will remember
It
you.
is not a provocation case, my lord. Clear case of.
We'll just adjourn the matter as it is, but still an uphill task.
My lord, this.
Don't say anything, just let it be.
My lord, then, if my lord have issued notice on quantum of sentence,
That
can we consider
we're just keeping it.
See the
We're not-
doctor and you're not for one.
We're rising now because your favor is there for Justice Oak.
So this matter
May I
is.
request one?
It will remain. It will remain as it is, so it will come up in July.
My lord, then granted me the bail, my lord.
No one
So both have issued notice in quantum of sentence, my lord, 12 and 20 years.
No,
Temporarily.
Not one mentioning. Sorry for.
I may suggest one thing, my lord, only.
no bail at this.
Grant the leave and let matter be considered. This I know. Then
If
only
we grant leave, it won't come for another 10
and
years.
put it in the July, in the month of July. We grant this, no problem.
They won't take more.
Yes, my lord.
This
Very well.
hearing on July
Any date, my lord, for convenience date.
21st August.
Permission for mentioning one minute.
Which I
Item 34. I have been engaged for respondent. Only papers have been given only today.
34 will not reach in any event. We're
Yes,
given only till
have some date will not have application. Have on date.
We also have the supplementary list. there.
Supplementary is there about.
Yes, that's the reason I have to occasion some date.
It will remain as it is. So it will come after vacation.
Bench is till 3, Mr. Kapunai.
Yeah?
Bench is till 3 o'clock only.
Only till 3
That's
we are
right.
sitting.
That's the reason for so that I can go before.
You can go.
Some date after.
You can go in any event. We won't take it.
Some date after occasion. Lord.
It will remain as it is. We remember your item number. It will not be taken up.
The reason for papers have been given to me only today. Lord, otherwise
We are not taking it up today.
You be in the library, it won't reach.
That's Lord.
It's like
वो तो आप ही करेंगे। हाँ।
With your lordship's permission, may I-
Yes, Mr. Patwal.
Item 35, it's an SLP filed by the Agra Development Authority, that land acquisition matter, where that cottage industries, the order relies on. Cottage industries, your lordship had already sent back for a fresh decision on interim and final. Now, my lord, the interim order in this is still the next date of hearing today. And 80 crores plus of our money lies attached because of the order of the trial court. May I request your lordships to, today I realize your lordship has a.
Today may not be possible.
I am here for the respondents.
Can it be tomorrow or day after, my lord? This attachment is a problem. And 84 crores is attached. And according to me, it has to go back. Our first appeal has to be decided.
You wait till the.
No, this is a 927 days delay.
It's all right. We will argue on merits. You will have.
This can only be in July. We are not going to have time tomorrow or day after.
Lord, come after years, my lords. And this was only, this idea is, my lords, to
This will have to wait.
I will argue.
July, till July.
All right. Then
Please
the
make a
interim
motion.
order was till next date of hearing. That may be extended till July.
We are not taking it up, so there's no hearing today.
All right. All right. All right. Understand. All right. July. Then some date.
Just leave it as it is. It'll remain on board.
All right. Then your lordship's court sec master will give some date in July.
No, it will remain on board.
No, it's not a regular matter. It's a miscellaneous matter. Item 35.
Not taken up today.
If it won't, if it's not taken up today, it will come automatically.
Very good. All right. Otherwise I will come before your lordship.
Why will it be deleted again?
All right. All right. No difference. So it will go July. Okay.
In item 36.
Yes.
So this boy needs help, my lord. It's not jail. The earlier case against him was over half a grand. Over a grand.
So second case, but.
So half of he requires help.
And the
Parents
persons,
have to-
and the persons
They've
who
been
he
granted
had named, those are the persons who are supplying him.
Yes, the suppliers have been granted bail.
They have been granted.
They are granted bail. Lord, I can also make. Can I press for interim? Can I press for interim? 20.
July.
Okay.
Service by shall be affected by all modes, including this.
Business. That is the anticipatory business. Now the petitioner is not named in the FIR notes. The main accused will not see the FIR notes.
You have 4 earlier cases.
No, Lord. Only one FIR note. Wrong information has been placed before the Honorable High Court notes. Only one FIR note is pending against me, notes, which I have mentioned notes, synopsis notes. Page number D notes, para number 2 notes.
No, but the High Court records the statement made on behalf of the state that you have 4
notes, because notes
antecedents.
Only one FIR notes and one case under section notes 4A public gambling which was disposed of notes. And not one civil matter is pending. One civil dispute is there. Which is also
gone.
Very much here, Lordship. Very much here.
What joint memo is this? I have not looked at the file because I thought
Lordship,
only fresh matters would be taken up.
Lordship, we both had filed appeals. This was with regard to the transfer of shares. Parties have settled and we have put
You've settled.
on record and it may be disposed of in terms of the joint memo, Lordship. That's the only way, my lord. We have filed a joint settlement memo.
Where is that?
And
We'll take it up at the end of the list after
Obliged.
fresh matters if there is time.
Obliged.
42.
My lord, for the petitioner, this is an anticipatory bail. I have only 2 submissions to make.
Sorry?
Speak into the mic louder. Speak it loudly into the mic.
Yes, my lord. This is an anticipatory bail. I have only 2 submissions to make. Firstly,
Can't hear you. A little louder.
now, my lord, am I audible?
Little louder.
My lord, I have only 2 submissions to make.
Yes.
Number 1, there's a 12-day delay in filing the FIR. And second thing is the weapon attributed to me is much more less grievous than the person who has actually inflicted the blow.
Here, there's one issue though.
Sorry.
The order of the High Court reflects that the complainant was heard.
That's correct, my lords. But
The difficulty is that the High Courts do not seem to implead them, despite the fact that here he filed an IA also. Or one of the other cases, there's an IA filed also. But the complainant is not made a party, but once he's given a hearing, we will also have to hear him.
my lords, we can implead him. My lords may keep it on the next date. We will implead him. And the co-accused has already been granted bail. The person was inflicted much more.
He's been granted regular bail.
Regular.
You want anticipatory bail.
Anticipatory bail. I understand that, your lordship.
Jagdish was murdered by the complainant. Is it? What happened to the complainant? Is he on bail?
Yes, my lord. He's on bail. He's been prosecuted. He has murdered my father.
Shankar Singh has murdered Jagdish, Virendra's father.
Yes, my lord. The informant.
Where are those bail orders? He's on bail out. When he did that,
I'll have to.
he filed the complaint while on bail, is it?
That I'll have to get more instructions, my lord. I don't
And
have-
the trial has started.
In this case, no, your lordship.
The complainant says so.
My lord, yes.
Before the High Court, he seems to have said that the trial has started and some. How is it possible? The case has been it's been split up.
No, my lord. I don't have clarity on that.
Fair is how many? How many days? 12 days.
12 days.
12
But it can also be a motor vehicle accident with the
16.
kind of injuries that he has sustained. That's a foot fracture, and that is from a private orthopedic.
12 days. Just the delay in the. Returnable on 26th August. In the meanwhile, subject to the petitioner joining and cooperating with the investigation in FIR number 100 of 2024, is it?
100 of 2020.
100 of 2024.
Oh, your lordship.
Right in the police station. He shall not be arrested.
But the subject matter of the arbitration ballot is a contract for preparing a bypass to NH11, which bypasses traffic flood in 3 roads. Now, the toll prospects which are part of the project report. Lordship, there is a delay of 39 days.
Delay condone, issue notice.
I am not at this stage pressing for any interim orders.
We are accepting.
There was an execution proceedings which had started.
5th August.
But of course, now that now it has been set aside.
You're on caveat for which there's only one respondent.
State.
State.
State is on caveat.
Mr. So-and-so and counsel accepts notice. Accepts and waives service of notice. Accepts notice on behalf of the State of Rajasthan, respondent number 1, and waives for the notice. There are other respondents also. Only
yes, PWD, it's a contract with the PWD.
You don't have to say yes.
And
Grateful. Because I am aggrieved by an obvious mistake of fact in the influent order.
You've not filed a copy of the earlier Supreme Court judgment.
Yeah.
Against the earlier.
Come to page 237, please. 237, paragraph 2.
Yes.
Kindly read it.
The empowered committee also approved the grant of another 2 years period from the date of issue of eligibility certificate for awaiting.
Not that. Sorry, I seem to have the top paragraph. Not that.
It was on page 236.
237, the first line at the top. Development will take further necessary action
in this matter in the light of the earlier decision of Honorable Supreme Court. Now,
that the earlier decision was applicable or not on this additional land. So obviously this court left that issue open. That is the reason why you have not filed a copy of that.
Unfortunately not.
That is what they say here.
Because I can pass on the order of the Supreme Court.
Why don't you file the relevant documents? You file the 2611 order, but you don't file the Supreme Court.
23rd August or 9th May. What is the date of the order? 23rd August 2011 order. SLP Civil 21246.
2611-2010 order is placed on record.
Gotcha.
But not the Supreme Court judgment. And according to the committee which deliberated, that Supreme Court order gave them the liberty to look into the question as to whether this kind of exemption was also applicable to the extra land that was given to you.
Because I'm on a slightly different aspect.
Without filing the relevant documents, we are not going to consider it. Place that Supreme Court judgment.
Because there is a
after July. These kind of mistakes are expensive, counsel.
I divorce that order if I am able to convince my lord.
No.
There is
once you do not file all the relevant documents, we are not even going to look into the matter. The earlier order passed by the Supreme Court has not been placed on record. Learned counsel shall.
Then comes MCA. Then comes respondent number 1.
You want us to say that there will be no IPL match.
We not see the contract.
This is the prayer in
This
your
is right,
section 9.
Not IPL, Lord. This is a local.
Whatever league matches or
Correct.
whatever those matches.
Lord,
Mumbai IPL.
May I just explain?
These are also called IPL.
Local IPL.
Shivaji Park line.
Yeah. So
Many stalwarts have come out.
That was my Lord's good.
You seem to come at the 11th hour all the time.
No, it's not so, my Lord.
2020 termination, 2024, you're aware that you're not been called for the meeting,
Can I-
and then you don't file the application till 2025 March.
I know what I'm faced with, my Lord. Can I just respond to this in 5
And
minutes?
then you come here also at the 11th hour.
No, my Lord, I'll tell you, my Lords, why. My Lord, my contract typically was with respond number 1. The person or the entity which is defending this action even today is MCA. MCA, after the termination on the 20th of January 2020, what my Lords is putting to me that you've come very late, till April of 2024 was engaging with me. That's on record. They said, give me a joint proposal, which your Lordship would find in the second volume at page 82. And they approved it in principle. You may not just see page 84 of the second volume. Lord Justice Sanjay.
How do you get over para 18?
No, I
of
will.
the
I'm
order?
not. In fact, my Lord, the difference.
Let him complete.
Lord, I'm facing the fire. He doesn't have to do anything in this. Correct? My Lord, first was delay. May I just satisfy your Lordship what was MCA to be? Because they say
there's no proof that this probability sports was even an agent of MCA.
My Lord,
that is what the
my Lord, your Lordship would see. Why would they ask?
You have an agreement with probability. That agreement in
Lord, please see the material and record which the single judge has not. Your Lordships have formed this opinion based on the judgment of the single
judge.
Make
the payments also in January 2020.
Lord, Lord, what was my grievance and whether they engaging with me? Lord, first please see the joint proposal at page 82.
Page?
82 of the second volume.
Second one.
Please see that. My Lord.
82. 82.
My Lord, the addition by page 82. Please see that.
You've not had any matches after 2019.
No.
You had only 2.
Lord, there were 2 editions.
That's
first and second. They didn't
after
go to
that,
2019
onwards, no.
No, my Lord, 22, 23 didn't, and this is the third. You have chosen for 5. Correct, my Lord? So now please see page 82. See, correct, sir? 2nd February. Is this the volume?
10th February.
10th February.
And it's addressed to probability.
1 second. Just I know.
10th February, Mr. Shankar.
Your Lordships are right. My Lord, please see page 92. I'm sorry, I said 82.
92.
Please see 92. Who writes this letter to me, my Lord? It's MCA. And it's addressed to us. This is an email. This is a reference to the meeting. Now, probability is obviously out of the fray. Held on 18 February 2021 at the MCA's office. As discussed in the meeting, you are requested your in or denial to the proposal sent by the T20 Mumbai League. This is the league governing council on or before 22nd February 2021 for us to proceed in the matter.
It should be a joint mail.
And your Lordship would also see, I am being recognized. No, no, my Lord, I am recognized as a team owner. PC. If MCA is not, Lord, in fact, probability is actually the tail which is wagging the dog. It's the other way around. Now, please see my.
Anyhow, you have to still initiate your arbitration.
Lord,
do that.
Would my Lord just see
at this stage? No question of granting you relief.
Lord, I am only
under section 9.
Lord, with the point is they are putting. Can I also say one thing? Please look at the impugned order, the last. They seem to have restricted me to the only damages. I may have a case because there are 3 more editions left. Page 21, paragraph. Does my Lord
probability has already been terminated by MCA.
No one was told about this. The MCA told us about this during the course of the proceedings. They have restricted me.
That is so far as probability is concerned.
No, not probability is not terminated, but I may get restoration. Why do they restrict me only to damages?
That is true. That
may not stand.
So your Lordship may at least clarify that.
Well, it's the agreement.
This restricting their claim at this stage doesn't.
No, your Lordship may say that.
They've not even filed a claim petition. Let's
section 9. Whatever prayers they want, we have no difficulty.
Only this part of it.
Very well, very well. But your Lordship should note today, probability sports is out of the picture.
No, anyhow, we are not going to go into all those.
It has recorded in this order.
We are not going to.
I don't know.
Yes.
Is this Lord?
We find no good ground and reason to interfere with the impugned judgment. However, we may clarify that it was not for the court dealing with this petition under Section 9 of the Arbitration and Conciliation Act 1996 to decide as to what should be the scope and extent of the claim to be put forth in the course of arbitration once it is initiated. To that extent, the observation in paragraph 20 of the improved order shall have no bearing or influence on the arbitration proceedings as and when they are initiated. Subject to the above observation, especially petitions.
Grateful, brother.
So, my lords, these are some applications.
Ms. Aurora,
My lords, okay.
once you are rank jumping candidates, you think that the commission had some special affection for you, that they picked your names out of turn? Obviously, they had sufficient initiative to jump ranks and pick you. No question of saying that you're not tainted, non-tainted candidates.
Okay,
And you can't have this review by way of these clarification.
My lords, may I make us endeavor at least on a couple of points, and if I'm able to persuade you, may I? My lords, my first thing is, as compared to the OMR sheets, those people had never participated in the exam. They had not filled up
The
any
degree of
applications.
tainting is not relevant. Once you are tainted, you are tainted.
So now I come to the question of my alleged rank jumping. And I have 3 submissions to make, and I request you to consider that. I know my lords have an opinion. My lords have heard this matter.
Heard this matter.
But my lords, 3 things that I emphasize.
Former Chief Justice has delivered a lengthy, detailed,
My
fully
lords,
reasoned
my
judgment.
lords gave
Because
us-
you did manage to find this loophole, but it's not really a loophole.
No, my lords, I would
It's
put it
clear
like
on the
this.
face of it.
I would put it like this. It is the case of West Bengal board that these were wrongly appointed. They have gone up with Babas. Now taking the allegation against me that I have become higher than some others and got appointed, so it could only be at my instance because I'm a beneficiary. I understand that's what the court is saying to me. My lords, my response is simple, and this is it. When the West Bengal board declares the result, it only puts our marks out there. There are no ranks. It is an admitted position that they never actually declared the result with all the ranks, everything out there. My lords, there would be no way how we could influence any case. Please appreciate, we are
Those
today.
general assumptions perhaps cannot be
My lords, we are
applied to a case of this nature,
lords, we are
where every manner of underhanded dealing seems to have gone on.
My lords, we are only 40 of us. Now, today, there is no final conclusion. What has happened? Who is responsible? But what will I lose? And why I'm before this court? My lords, the jobs are gone in any case. Today, there is an opportunity of participating in the fresh round where exams will be held. We have worked for this last 7-8 years. Now, my lords, at least allow us that opportunity because we've lost our previous jobs. There is no way we can go back.
Opportunity to?
My lords, to participate in the exams now. My lords have said they have to reconduct and reappoint there. So, my lords, that opportunity is lost to us unless and until my lords give us this small window. My lords, we've lost a
That
job.
is practically asking for a review, not possible.
So, my lords, I am not saying on a review.
Sorry, sir. We find no good ground and reason to entertain these applications, which are purportedly filed for seeking a clarification of the order dated, judgment and order dated 3rd April 2025, passed by this court in Civil Appeal number 4858 of 2025 in batch. The applications are accordingly dismissed.
My lords, I'm grateful for the hearing.
What is the item? 38.
My lords, we have 2 other applications. We are on a completely different footing. They're coming on Friday.
Which one?
We'll be here on Friday.
In the disposed of, the West Bengal man.
Yes.
Ms. Nandi had also.
We'll be here on Friday. The court, we had mentioned it before the Chief Justice, and he had said that it can be listed on Friday. We'll be here.
Very good.
We have not been served with any copy.
Please do that.
We'll do that.
But rarely do we have an advance intimation like this in court.
Roll about the fairness, my lords, on this side.
38 go on. No representation. No representation even on.
Lords, this is a unfortunate matter, Lords. The lady is widow and she's not.
But what about all these
Please, Lords, this
refusals of the summons?
Please, Lord, that's very
How many
unfortunate.
times though?
Please, Lords, that's very unfortunate. She's an illiterate lady. She never knew, Lords, what's happening
He
with her.
just needs to refuse everything that comes.
No, Lords, I don't have much to say on that.
So there's nothing wrong with the bailiff. There's nothing wrong with the bailiff.
You're not really saying that this didn't happen.
Lord, this happened.
He did come, he did offer.
Please,
Then
Lord.
what is
Lords, I am before the equitable jurisdiction of your lordships today, Lords. Lords, we say the amount.
Now you are directed to pay some 10 lakhs.
Please, Lord, I'm on
For
that.
what reason? What is this decree about?
Lords, please. So basically, I entered into an agreement to sale, and for my residential house, this is my only house,
So
Lords.
you received this money.
I received 5 lakhs, not 10 lakhs, Lords. Now, what the prayer in that interim prayer in that suit was to give 10 lakh rupees, which.
How long did you keep that 5 lakhs?
No, Lords, I am ready to return that 5 lakh.
No, how long did you have it with you?
Lords, I still have that with me.
How long?
Lords, this agreement to sell was entered into 2021.
Secondly, your ex parte decree against the ex parte appeal is also dismissed by the High
Please,
Court.
Lords.
Have you appealed against that?
No, Lord, that was challenged, Lords. Those orders were challenged before the High Court, before the district judge, and now before the High Court. So against both these.
No. A party who set ex parte has 2 remedies.
Please, Lords.
One, he can set aside the ex parte decree.
Please, Lords.
Or he can appeal against the
decree
itself.
Please.
Section
That also
96.
you didn't.
Please,
You appeal and appeal is dismissed, it says.
Please, Lord. Appeal is
Against
dismissed.
the decree.
Appeal against the decree is dismissed.
Yes, Lords.
You also filed an Order 9 Rule 30.
Yes, Lords. That's the subject matter.
Order 9